Okay, well, good morning, everybody. It's 10 o'clock and the inquiry is resumed. My name is Guy Davis. I'm the inspector appointed by the Secretary of State to hear this appeal. The appeal is brought by Retirement Villages Developments Limited against the decision of Surrey Heath Borough Council, who refused planning permission for a mixed residential development on a site at land at Snows Ride, Windlesham in Surrey. The inquiry opened last week. We're in our second week, hearing the rest of the appellant's evidence before we move on to other matters. Before we get on to the main business of today, can I just run through some housekeeping matters? First of all, if you've got mobile phones, can you please turn them to silent? Same for those with laptops. Fire alarm. There is actually going to be a fire alarm test today. It's at 10 o'clock, so when it goes off, we'll just have to hang tight for a few seconds until that clears. If it goes off at any other time, we'll assume that it's real. Can you please leave the building by the marked fire exits and congregate in the Knoll Road car park and await further instruction. Can I remind people to use the microphones if you are speaking? So, Mr. Gocher, when I call you to speak, just press the button. It goes red, and you know that you're live. The reason for that is that we are being streamed, and the cameras pick up whoever is speaking on a microphone. We have had a request for a further speaker this morning, Mr. Gocher, which I've accepted, and I'll give him that opportunity to do so after my introduction. I've got two bits of housekeeping. Otherwise, that is, as I understand it, a final Section 106 has been agreed. I haven't seen it as yet, so if I can have a hard copy at some point, in fact now would be a good time, please. And has electronic copy gone to the council for putting up on the document library? Okay, thank you for that. I obviously prepared for the roundtable session a little later today based on an earlier version of it, so we'll just have to pick up what changes have been made at the time. Second thing is that we received an email on behalf of Mr. Henderson, two things in it, some fairly minor corrections to typos and the like in your proof. I have no problems with that. But you have also included an appeal decision. Now, I think I need to ask why are you including that at this late stage, and is it of any real relevance to the inquiry?
Yes, let me explain. So, Mr. Pycroft in our team identified this on Friday. It came out on Friday, I think, and having looked at it, it has parallels with this case. That's why we'd like you to look at it. Obviously, we couldn't have introduced it earlier. I had this in my most recent appeal in Suffolk. That appeal decision had actually been out for a month, but the first we became aware of it was that day. Obviously, you're going to hear from a learned friend on his position about it. His witness has given evidence. I am not adverse to the witness being recalled, and I can just ask about the relevance of the case, or they can put in a written note, or they can deal with it in closing submissions. But I would invite you not to close your eyes to it because of the parallels there. All of that said, it's entirely at your discretion, and if you say, I don't want that, then we will respect your decision on that, and that's fine. But from the client's point of view, obviously, there is a desire when there is a similar case to say, well, that is relevant and we'd like you to see it. But I put it no higher than that.
Is it the same company then?
No, it's a different company.
Okay.
But Mr. Henderson in particular has been through the decision and spotted similarities. And it's for that reason that we would all like you to see the decision.
Mr. Atkinson, do you have a view on that?
Yes, I'm happy for it to go in. What Ms. Fitzpatrick has done overnight is look at the find and look at the Section 106 referred to in that decision, and I'll be asking questions of Mr. Henderson about that.
Okay, well, on that basis, then I'll accept it. Could it please go on to the document library? Mr. Atkinson will have the opportunity to ask questions at a due time.
If there are going to be questions on the section 106, obviously we haven't put that in, and that's not available to us through knowing about an appeal decision. So if my learned friend could provide a copy to Mr. Henderson, then it'd be, otherwise we haven't got that document before the inquiry.
I'm not sure I'm able to at the moment, and you'll see Ms. Fitzpatrick is also stuck in traffic. It's a simple point. I'll try and get hold of it, but I'll put the point to Mr. Henderson anyway, so he can.
I don't mind, but obviously, in fairness to him, he needs to see it before we get to re-examination, and I need to see it as well. We can't sort of say, well, there's a document and it says this, and nobody, including my learned friend, has actually seen the document. That wouldn't be. And I'm not trying to object to the line of questioning. All I'm saying is procedurally, we're all going to be talking about Section 106 that nobody's seen, and that is problematic. So perhaps we could leave that to the end of cross-examination and then see where we are, take a short break and see if the document can then be circulated, because, we have a starter for 10.
Thank you. It's on that council's website, Tanbridge District Council.
Yeah, if you could just PDF it and send it round so everybody can see it, that would be great.
Yes, I can.
Yeah, I mean, you can't be too fussy about this, Mr. Young, can you? Given
No,
the circumstances.
I was about to say, it came in late. They're doing their best to respond to it. I mean, I'm almost thinking, well, let's hear the question. If the question begs the need to look at a document, then we could do so. But if Ms. Fitzpatrick can PDF it and send it round, then that seems to be would solve the problem. Okay, let's try and do that. Okay, I haven't got any other housekeeping matters. Anything from the main parties? No? Anything from you, Mr. Atkinson? In which case, let me turn to Mr. Gocher. I've had a request from Mr. Gocher to speak, and I'm happy to allow him to do so. So, Mr. Gocher, some questions to you first. Can I ask whether you are representing an organisation or just yourself? Okay. Could you put the microphone on? Thank you. Just repeat that.
Myself and my neighbours.
Okay. And do you oppose or support the proposal?
Oppose it.
Okay. In which case, over to you, if you'd like to make your statement, please.
Thank you. Good morning, everybody. My name is Harry Gocher. I've been a resident in Windlesham for 47 years and live on Mill Pond Road, adjacent to Snows Ride, and have seen various developments happen around our village over time. I've read the plans, and this one is of particular concern to me, and one that I'm strongly opposed to for the following reasons. The loss of a greenbelt countryside site to retirement villages is inappropriate development. I see no very special circumstances to justify building on this greenbelt land, especially when we're surrounded by retirement apartments, where companies are having difficulty selling from new and individuals have difficulty selling on the resale market. There is no local shortage of this sort of accommodation. This development is likely to bring in most residents from other areas, which will in turn put a strain on our healthcare in the village, which is already being challenged and will put extra pressure on local GP surgeries and dentists. It is unlikely that a GP surgery will ever be built. This was proposed when the windmill field development in our village was put forward several years ago and did not happen in the final plan. Our surgery in the village was taken away several years ago, and bringing more retired people into our village will add great pressure to a service that is already overstretched. Traffic congestion is already a problem. 154 retirement units and 33 further dwellings, together with visitors, staff and service vehicles, will generate problems leading onto Snows Ride and the A30. Although some retired residents may not have cars, several will, as there is no public transport in this vicinity. The proposed footpath on Snows Ride is only in the complex itself and does not continue outside. Walking on Snows Ride is potentially dangerous, particularly for elderly people. It is dimly lit at night and cars do not adhere to the speed limit a great deal of the time. Sadly, Windlesham Village has become a rat run for cars due to the increase in developments in the area and an increase in road traffic. This proposed plan will more than likely be more for the comfortably off retirees. I do not see affordable housing, in inverted commas, being something that those in a low income will be able to afford on this particular luxury site. How would the purchase of a retirement village complex feel about having such accommodation available as a part of their village life? Hardly a good selling point, I feel. There will be a great loss of biodiversity. We're constantly being told we should try and preserve for the good of everyone, both for enjoyment and well-being for our mental health. Building on that site will destroy natural habitats. This land has had flooding in the past. Replacing open greenbelt pasture with concrete, roadblocks, apartments and other dwellings will increase the risk of surface water flooding. To summarise, this proposed development is inappropriate within the greenbelt. It fails to meet the golden rules within paragraph 155 and 156 of the National Planning Policy Framework and will be harmful to the appearance and character of an open space that residents enjoy and hopefully will be able to continue to do so for the future. The loss of greenbelt is permanent and this should not be disregarded. I care passionately about our village and its community. We accept change, but this does not play by the rules. Thank you for giving me the opportunity to express my views and those of so many of my fellow residents who also care about the future of our village.
Thank you, Mr. Gocher. Just help me, Mill Pond Road, where is that in relation to the site?
If you go from School Road,
Yeah.
where the school is, you go up Snows Ride, Mill Pond Road with the first road on the left side.
Okay, yeah, I've got you.
Push my speaker. I should say it again.
Okay,
If you come off of Snows Ride, you go up, if you come off of School Road, go up Snows Ride. First on the left is Mill Pond Road, and we live just down on the right.
okay, thank you. Any questions at all, Mr. Young?
Just what, forgive me, Mr. Scotcher, I'm not going to trespass on your various concerns, apart from one, which is where you talked about there being a lot of this accommodation in the area and it's having difficulty selling. Are you including in that some of the schemes that I've seen whilst driving back to the M3? There's Churchill, I think, McCarthy and Stone. Are you including those?
The ones I'm talking about are, as I come from where I live in Windlesham, I come to Bagshot. On the left side, there are two developments there, one for the over 70s, and I believe the other ones are McCarthy and Stone. Yeah. I also have a friend who lives at Audley Village in Sunningdale. They're having great difficulty selling them for all the plans that are put in place, all the different clauses that there are. One person bought an apartment there, is having to move for health reasons. They can't sell it. They haven't been able to sell all of the ones on this phase.
Well, I know the ones you mean, it is McCarthy and Stone, and then there's another retirement operator. That's fine, thank you.
Okay, thank you very much, Mr. Gocher. I see you were speaking from some notes there. Are we able to have a copy for the document library? If you could give the council a copy, they'll upload them to it.
Yes, absolutely. Thank you.
Thank you very much. Okay, let us then move on to the main business of today, which is to hear from the appellant's planning witness, Mr. Henderson. I think I need to say no more, in which case over to you, Mr. Young.
Thank you very much, sir. Mr. Henderson, if I can introduce you to the inquiry. Your name is Rob Henderson, is that right?
Yes.
And you're employed as a planning director at the Solent office of Pegasus Group, is that right?
Yes.
Which was established in 2000 and since grown to employ 550 professionals. You personally have a Master of Arts degree with honours in town planning from Heriot-Watt University, is that right?
That's correct.
You've been a chartered member of the Royal Town Planning Institute, and you've worked as a professional planner for 27 years, is that right?
Yes.
Before joining Pegasus as a planning director in July 2024, you previously worked for Wealdon and Lewis District Councils and a series of private consultancies, including Babcock and then Savills as well. Is that right?
That's correct.
Good. Okay. Thank you very much for that. I'm going to turn to the points that you wanted to raise. The first issue is about the status of the site and its status in terms of the use classes order. What is the position, please, as far as you're concerned?
At present, I would regard the use class to be agricultural land.
Okay, and then the proposed development?
It's a composition of Class C2, Class C3 developments, along with an area of public open space.
Good, okay. In terms of the most important policies for determining the application, which is the phrase the NPPF uses, which are the policies that you think fall into that category, please?
I've identified the most important policies as those that were stated in the reason for refusal, and in addition to those three policies, which are DM9 of the core strategy, DH1 of the draft emerging local plan, and WNP 2.1 of the Windlesham neighbourhood plan. I've also included policy CP6 of the core strategy, which deals with the issue of affordable housing.
Good, okay. Now we know, and it's agreed, that those are obviously out of date as a lack of a 5-year land supply. How should the inspector approach that in terms of the weight to give those policies in light of the age of the plan and other considerations?
Well, sequentially, the core strategy as a whole, I would consider to be out of date by virtue of the absence of a 5-year housing land supply primarily, but also having regard to its age and the fact that it was prepared fully in advance of any version of the current national planning policy framework. But obviously, the weight that then is applicable to the policies that sit within that will vary based on the degree to which they influence housing delivery in this case.
Yeah, I mean, part of the council's case is to say, well, look, if you look at paragraph 232 of the NPPF, that's the implementation part, it says that the existing policies should not be considered out of date simply because they were adopted or made prior to the publication of this framework. Now, obviously, that's the December 2024 version, and we've had about 6 different versions. But their point is, just the age of just because the plan was adopted in 2012, that doesn't make it out of date, or the policies out of date. You've obviously referred to the 5-year land supply. Through cross-examination, we've established that does make them out of date. But also, just looking at the nature of the plan, please, and what it was seeking to do, what are your views about the relevance of that to the weight to give policies, such as the housing policy or CP1, which seeks to define settlement boundaries and so on?
So CP1 is the spatial strategy for housing delivery, which, as has already been discussed this week during the inquiry, was established at a time under very different circumstances, where the assessed need was significantly lower than it is today, or indeed, as is transitioning through the emerging local plan process as well. So I fully consider that the settlement boundaries are out of date, greenbelt boundaries are out of date, having regard to the expectation of national planning policy that a local plan should plan for to meet its assessed needs. Okay,
then the crux of the matter, although there are lots of policies referred to in the council's proof of evidence and so on, the inspector is only really concerned with breaches of policy. As far as the local plan is concerned, the only breach in the reason for refusal was with reference to DM9. Is this proposal in conflict with DM9?
So policy DM9 is a design principles policy, which on the face of it, I would say is concerned with the kind of the detail generally of development. So we've already almost moved past the kind of like the principle stage by the time we're actually looking at this policy. But if I'm forensic, there are 9 components to the policy. I think we're fully in compliance with 8 of the 9 components, which leaves us with criterion 2, which has 2 sort of distinct elements to it. If I was really trying to kind of give the council the benefit of the doubt. And obviously, if the inspector ultimately was to find that there was some adverse impact on character and appearance attributable to the presence of built form on the site, then I would say that there is a minor breach of essentially the first piece of criterion 2, which is that a development should respect and enhance the local, natural and historic character of the environment. The council's case has been local character, and in circumstances where harm was identified to local character, then I would say that there is a breach of that component of the policy. But of course, criterion 2 then moves on and says that we should be paying particular regard when considering the impact on character to matters of scale, materials, massing, bulk and density. And as we have sort of almost moved beyond the in-principle position at the point at which we're then considering those matters, I consider that the development that would be established in accordance with the parameter plan could, in fact, enhance the character of the area, having regard to those particular criteria.
Okay, I mean, in your proof, you refer to the fact that part of the policy requires the development to respect and enhance the local, natural and historic character of the environment. We are putting greenfield development onto putting development onto a greenfield site, which is in the green belt. Is that respecting and enhancing the local and natural character?
Well, it's a matter of judgment. Obviously, I was present in the room when our witness, Mr. Hammond, gave evidence last week, and in his view, there was not. I have some sympathy with that view. In my proof of evidence, I attributed limited harm to the character of the area simply because of the change from open, undeveloped field, paddock, to a built form. But I was clear that in the context of the development that would replace that open character, I see opportunities to enhance the character and appearance of the area.
Yeah. Okay, so, I mean, the inspector will want to know clearly what the appellant's case is. Are you accepting a degree of conflict with DM9?
Yes.
Yeah, okay. All right. We know, obviously, that just being in breach of one policy or part of one policy or an element of part of one policy doesn't mean that you conflict with the development plan as a whole. What is your position as far as the local plan is concerned? Is this proposal in conflict with the development plan as a whole, that element of it?
No, I consider it to be in compliance with the local plan as a whole.
No, and indeed the officers, although they did conclude there was a breach of DM9 for the reasons set out in the officers' report, they also recommended approval because they felt very special circumstances. I'm leading because it's agreed.
Yes.
Because they felt very special circumstances were made out. Yes.
Correct.
So even if the inspector accepts there's a breach of policy DM9, which you're accepting, and even if he thinks it's more extensive than you do, we know it's just confined to that one criteria because that was accepted in cross-examination, DM9 Part 2. Does that in any way, or no, not in any, does that stand in the way of granting planning permission for a proposal on the basis it complies with the development plan as a whole?
No.
No. Okay. The other component of the development plan that is alleged to be breached in the reason for refusal was WNP 2.1. So if we go to the core documents and have a look at that. The Windlesham Neighbourhood Plan is CD 4.4, and if you've been there before, it'll suddenly open on page 26 of 46. Do you have that?
Sorry. The document's just opening.
Yeah, no.
And we're going to...
Policy WNP, I think 2.1.
on page
26 of 46 in the PDF.
Yes.
And it says new housing, the policy is new housing development features and compatibility. Proposals for new housing development or extensions of existing dwellings shall be supported if they respond positively to and protect the built and natural character features of the setting of Windlesham Village. Planning applications shall be supported if maintain established density, maintain the general scale, maintain the style and pattern of separation. Just help us with this policy, please. Clearly there is wording borrowed or taken to be consistent with DM9 because it talks about protecting the built and natural character features. But do you think there's a breach of this policy?
No. To the extent that the policy, which obviously is concerned with or affects housing delivery, is out of date. In addition, there are components of this policy which sort of conflict with both sort of ambitions of the neighbourhood plan set out elsewhere in the plan to deliver, to particularly focus on delivering smaller homes to meet the needs of younger and older people, and also the requirements of the framework that effective and efficient use is made of land, and therefore there are components of this policy in the detail which I would say are no longer appropriate or in force.
Yeah, I mean, maintaining established density is always very popular with local parish councils and so on. They'd like everything to stay the same, in effect, or either no development or development that's very similar to everything that already exists.
Yep.
Is that consistent with paragraph 130 of the NPPF in circumstances where there isn't a 5-year land supply and the policy requires optimisation?
It's wholly inconsistent with Policy 130 whether or not there's a 5-year housing land supply, but certainly in circumstances where there is an absence of a 5-year housing land supply, then that would be critically in conflict.
Yeah. But your position is, look, there's no breach of that policy, and you've been clear about that. Even if there is a breach, let me ask you that, given the situation, given the lack of 5-year land supply, given the NPPF, what weight do you give this policy in the circumstances of this case now?
I would give it very limited weight.
Okay. Now, the council, through their witness, have introduced a new reason for refusal, and that is reference to CP1, and we dealt with that in cross-examination. It was accepted that it should be given limited weight in circumstance. I think it's limited weight, it's only reduced weight in circumstances where this policy isn't addressing the housing needs of the area, lack of 5-year land supply, etc., etc. But the council's case, I think, at its highest on this policy, although this wasn't really explained, is to say with the last paragraph, within the countryside, because we are outside the settlement boundary, the current extent of the green belt, which obviously goes up to the edge of Windlesham and covers the site, will be maintained. So it would appear that what is alleged is you're in conflict with that policy because you're in the green belt. Number of questions on this. First of all, does this policy or any other part of the local plan adopt or import the very special circumstance test, which has been part of national policy since, for decades, frankly?
No, it doesn't.
No. Can we comply with this policy if you are correct and very special circumstances are made out?
Yes.
Yeah. So is there, and that is your case, that is the appellant's case, so is there a breach of this policy?
No.
No. In any event, if the inspector would say, well, I think there is a breach of that particular sentence, what weight do you give it in light of the fact that there's no very special circumstance test in there, the policy is predicated on settlement boundaries from RSS housing figures, those are out of date, and there's a lack of 5-year land supply, and the council is itself having to release land, greenfield land and greenbelt land as a consequence? What weight do you give the policy?
I give it no weight.
Okay. I think that deals with all the policies that refer to. There's an emerging policy which is said to be in breach, which is of a similar vein, isn't it? I think it's a design policy, is that right?
Correct.
It's agreed limited weight to the emerging policy. We haven't had the inspector's report. We haven't even had made mods. We don't know what the actual housing requirement will be and so on. In those circumstances, what weight do you give that policy?
Limited weight.
Good. Just bear with me while I go back to your evidence in chief.
That's policy DH1 of the emerging local plan.
Thank you. That's important to clarify. You have said in your evidence in chief, I think that's one of the other most important policy is CP6. I think that's right. Is that
Yes.
right? Let's just have a look at that and just explain why, your approach to that policy. We're obviously having a debate about affordable housing and affordable housing provision in this inquiry.
Yeah.
Just talk me through your reasons why it's one of the most important for determining the application and the weight to give it.
It's important because one of the key components of the council's sort of evolved position in response to this appeal is to have downgraded the value of the affordable housing offer that's been brought forward as part of the appeal development, which we have always asserted exceeds the requirements of the local plan. Policy CP5 and CP6 taken together combine to set out the local plan position on the delivery of affordable housing. CP5 first sort of sets out a sort of an overarching ambition for the delivery of affordable housing across the borough, with percentages of affordable housing that it aspires to deliver, and a tenure mix. CP6 tightens that, indicating in its second paragraph that the Borough Council will encourage market housing, and unless evidence of housing need or viability suggests otherwise, generally expect intermediate affordable housing and social rented units to be provided in accordance with the strategic housing market assessment or other subsequent assessments. The reason why that's relevant is there's two pieces of evidence that would then justify a discussion about the tenure and quantum of affordable housing that it may be appropriate to deliver in any given circumstance. The reason I think that's important is because, one, it means that the suggestion that a 50-50 split of social rented housing and intermediate housing is perhaps kind of overstating the force of that policy. And obviously it's relevant in the context now of the evidence that we've heard with regard to the viability of the development, and obviously in the light of the evidence that has been put before the inquiry with regard to housing need.
Good. I mean, you referred to CP6 being one of the most important. Should we include CP5 in that list, or is it just CP6?
I think the trigger is CP6, but CP5 is a scene setting, so I think the two can be read together.
Okay, all right. Just for the closing submissions. Good. I mean, it's quite clear in both policies that viability is identified. The appellant submitted viability evidence. The council say, well, you didn't do that at the application stage. But just to be clear, was it submitted to the council before the exchange of proofs of evidence?
Yes, the financial viability assessment was submitted to the council on the 13th of February,
Yeah.
Which was just over a month before the exchange of proofs.
Good. Okay. And have the council challenged the contents of that in any way?
No, the engagement we subsequently had with the local authority was that they were going to commission an independent evaluation of that information, and we had anticipated that the inquiry would receive some kind of indication of the findings of that, but the response we've received is no comment.
Yeah, I mean, whether they did or not doesn't matter from our point of view. They may have done, they may not have done. the point is there is no evidence to challenge the viability. Is that right?
That's correct.
Yeah, okay. And viability obviously allows for the different approach. It is notable, please, that CP6, the Borough Council will promote a range of housing types and tenures for both market and affordable. We've explained why the offer is as it is. As the councillor pointed out, you can't raise viability in a grey belt case. So, we are in a very special circumstance case. In your opinion, does this proposal, with the range of housing that is offered, does it match that ambition or the policy requirement to have a range of house types and tenures?
I think it does.
On the tenure side, obviously everything is home-owned, isn't it? So it'll be homeowners in the retirement village, but they are on a long lease. Is that right?
Yes.
Yeah, I mean, it is leasehold, the inspector's note, but with the ownership during your tenure, as it were, and then they have the right to sell it. Is that right?
That's right. What I would qualify is...
Sorry, I'm not quite sure I understood that. Just run that one past
Okay,
me.
yeah. So you become the occupier of your retirement village home or unit, but the actual legal status remains leasehold, and that's why we talk about them being leased. But they are owned. It's just to ensure that retirement villages continues the ability to control the whole village in that sense. Home ownership for the affordable and home ownership for the self-build, yes?
Correct.
Obviously, all of this goes into the mix of the very special circumstances. Can you see any reason why there's a breach of CP5? Well, not the council have alleged it anyway, but CP5 or CP6 while the inspector's deliberating over this?
No.
Okay, next issue I want to ask you about is grey belts. It's agreed it's grey belts. It's agreed that goes on the harm side of the equation. So rather than treat it as an additional factor of benefits, it diminishes the harm associated with it being in the green belt. That's been agreed. That's your approach, as I understand it.
That's correct.
Yeah, as set out in your proof of evidence. Why do you think it's important in the context of Greenbelt policy to acknowledge its grey belt and what that means for the analysis of the harms that we consider as we're considering in this inquiry?
In terms of kind of almost quantifying the magnitude of the harm, it helps us, and it helps us that it's a position of agreement because it's already chipped away a number of the components that contribute to the value of the green belt. So by identifying the land as grey belt, to some extent it follows that it is land that has the spatial capability to accommodate development in circumstances where that development is delivering sufficient benefits to outweigh the sort of the modest degree of harm that would then arise to the green belt purposes. Yeah.
Okay, and grey belt is, I think, defined as being more able to accommodate change. Is that how you see it?
That's absolutely how I see it.
Yeah, okay. With the inspector will note from your evidence, you give limited weight to the harm to openness, both the spatial and the visual. Just explain that, because the council give it moderate weight for the spatial and significant weight to, I think it's significantly harmful in terms of the visual. Why do you apply just limited weight to those two factors?
It's because it's a combination of designation, and having already established that the land may be defined as grey belt. Clearly, that has already kind of established that in spatial and terms, the degree of harm to the purposes and openness of the green belt is quite reduced. Of course, I've then been to the site, and the site that I've seen which I'm sure we'll come on to, has a peri-urban character where when you're on the site, you are very aware of the presence of the degree of containment of the site, two, the presence of sort of urban forms of development on its perimeter, which contributes to that sense of kind of enclosure by sort of built form, if you like, well, I'll stop there.
Okay. You, in contrast to the council, you're giving limited weight to the spatial and visual harms of waywardness, but you think there's significant harm to what we call the definitional harm and what's been agreed to reflect the purposes. We know that only one purpose is offended, and therefore, let me ask you, why did you say there's significant harm to the definitional stroke purposes?
So the substantial harm, actually, and that's basically to reflect the direction of national planning policy framework. That in the inappropriate development in the green belt, whatever the particular characteristics of that development or site, must be afforded substantial harm.
Yeah, I mean, if the inspector accepts what you're saying, then you are acknowledging that degree of harm to the green belt, but you say the very special circumstances outweigh that because of the way you give the benefits. Yes?
Correct.
Yeah, we have to add in other harms, and the council's case is about the harm to the character. We've had lots of evidence on that, so I don't want to repeat that. But if the inspector accepts that and accepts there's a degree of harm and breach of DM9, would that change your mind? You've acknowledged a breach of DM9, so I suppose that's already in there, if you like.
Yes.
Is that changing, if a different view is taken, there's more harm than you said, would that change your view about whether very special circumstances are made out in this case?
No. Clearly my judgment is informed by each of those components individually, including my assessment of impact on the green belt, its openness and character. But I also say in my proof that the package of benefits that's actually proposed in this case far exceeds anything I've seen in comparable circumstances. On sites that arguably were more open in the green belt and where the potential was to have greater impact on character than is the case here. So my view is that the weight is so firmly on the side of the package of benefits that even if one were to sort of up, as the local authority has, in fact, it's one's the sort of assessment of the impact on those facets on the harm side. I think you'd have to go quite a long way up that scale before you'd get to the balancing point.
Yeah, and then let me repeat the point. If you add in harm through loss of agricultural land, that isn't a reason for refusal. There isn't a policy referred to, but the council raised that. And obviously, there will be land that will be irretrievably removed from potential agricultural use.
Yes.
Because I don't mean just horse grazing, but in a time of emergency, growing crop on it. Again, do you acknowledge that's a harm, another harm?
Yes.
Yeah, and again, if you add that in together with the harm to character and appearance at the level the council put it, does that, in your view, cancel out the benefits such that very special circumstances are not clearly demonstrated?
No.
Okay, we've considered all ramifications.
Yeah, let me press you on that point, Mr. Henderson. Do you see it as a harm, loss of agricultural land?
I acknowledge it as a harm in the context of the policy background, but my understanding is that the site has not functioned in an agricultural sense for some time, and therefore the degree of the loss, both in terms of the relatively limited area of land that we're talking about, but also the agricultural function in practical terms. The combination of those two things, I think, there is a loss, but it's very limited.
All right, thank you.
Okay, and the point of this exercise obviously is to make sure that everything that might be considered relevant is considered relevant, and decision maker has taken account of it. Weights obviously for the weight ultimately for the decision maker. Let me just ask you about this point about the SANG. Mindful of the inspector's words, I don't want to spend too long on any hypotheticals, but the council have asserted, look, anything of more than 136 dwellings would have to provide on-site SANG, because the council won't allow its SANG to be used for that purpose, and they are obviously a gatekeeper in that scenario with that one SANG site. What's your view about that?
I sort of revisited the SPD after this came up in discussion last week, and to try and understand what drivers might sit behind that 136 number. And to that extent, I would kind of, I find myself at paragraph 4.3 of the SPD. I'm not sure whether it's helpful to go
It's
there.
CD 4.6, just for your note, and paragraph 4.3 on page 14 of 32.
Yes.
Yeah, your observation?
Yeah, so the first words in paragraph 4.3 are as a guide. It will usually be possible for developments of fewer than 136 net dwellings to take up capacity at strategic SANGs. So strategic SANGs are defined elsewhere in this document as SANGs within Surrey Heath that are controlled by Surrey Heath Council, or SANGs outside of Surrey Heath that are controlled by the respective local authorities of those areas. So it doesn't include any SANGs that might be under private control, for example. So the words as a guide would suggest from the get-go that there's some flexibility in terms of that 136 number. The 136 number has a footnote against it, which is at the foot of the same page, which helps us because it says that this is the minimum number of dwellings necessary to generate a requirement for a minimum of 2 hectares of SANG, based on sort of average occupancy calculations in development. I think it's just a sort of, it's been established as a kind of like a sort of a point at which the scale of development perhaps tips into a scale at which the delivery of on-site SANG might become feasible. We know in the case of our development that our 8.6 hectare SANG, which is 4 times the size of the one that would be required for a 136 development, is the size that would be probably close to the minimum size that would be necessary to actually have a functional SANG. So it's an interesting way that they've gone about this. But the crux point here is that 136 seems to be a kind of a capacity management tool for access to strategic SANGs controlled by the local authority, and that there is a degree of flexibility on it in certain circumstances, and that. If I can then take you to paragraph 4.20, which is on page 17 of the same document. This paragraph says that the strategic SANGs, those controlled by the local authority, primarily provide avoidance measures for developments that are in most cases unable to provide on-site bespoke SANGs. This includes small to medium-sized developments of less than 136 units. In addition, larger developments in the western urban area that are unable to realistically provide land for SANGs may also be able to use capacity at strategic SANGs. So that's a circumstance in which developments of more than 136 homes may be able to access the strategic SANGs. And it then goes on to say this approach may also apply to sites outside the area, outside of this area, the western urban area, that have particular site-specific circumstances which support the need for off-site SANG provision, subject to the availability of SANG capacity. So that's a further circumstance whereby development proposed outside of the western urban area of Surrey Heath District may be able to access the council-controlled strategic SANGs under the terms of this SPD. So what I take from that is there's a significant degree of flexibility in terms of the ability to access strategic SANGs. And actually, more than anything else, the purpose of that 136 number is just, it's a capacity management tool for the local authority controlled SANGs. That's what I take that to be. It has no ecological purpose. It doesn't appear to have any relationship with any sort of guidance or control that Natural England might, for example, seek to bring to bear.
Yeah, I mean, there is a danger, isn't there, that local authorities start to stop development, inhibit development by using SANG as if you like, a constraint policy. The SANG has to be approved, or it should ideally be approved by Natural England. Is that right?
Yes.
And has this one been the subject of objection from Natural England?
The SANG on the
site,
Hill Development site was modified to its current design and extent during the course of the planning application in collaboration with Natural England, and their final response was favourable.
Yeah, so we've got approval from the statutory consultee. The council thereafter may produce SPDs and so on, but ultimately, if a proposal comes forward and the solution proposed by the developer is acceptable to Natural England, would that be sufficient?
Absolutely, yes.
Yeah. I mean, just to be clear about it, retirement villages wanted to look after the SANG as part of the proposal. The council have refused that. The final negotiations we've had over the Section 106 has meant that it has to be passed to a third party. That third party is named with a sum of £1 million. That's the price that the council have effectively extracted by passing it to a third party, not connected to the council, I hasten to add, but from what was assumed to be a part of the management of the village is now an additional £1 million. Just for your note, so that is in the viability appraisal work. So it's already gone in to Mr. Guy. It's not an additional sum. But the council have insisted on this, haven't they? They have said even with retirement villages being present, they must pass it to a third party.
Yes.
With the price tag that it went. Is that right?
Yes.
Yeah.
By way of explanation, the Natural England consultation response indicated that in order to satisfy them, that the SANG would in its longer term maintenance and management be fit for purpose, and that step-in rights should be afforded to a responsible authority, and in most circumstances that would be the local authority, i.e. the local authority would utilise its enforcement powers to ensure compliance with the agreed SANG management plan. But Surrey Heath was unwilling to perform that role in this case, and we heard last week that they have had their fingers burnt in another situation, and we weren't able to reassure them that the circumstances in this case were sufficiently different that they would be protected from that, so that as a result, this third party has needed to be involved.
Yes, because if we want a signed agreement, we just have to agree to what they want, don't we?
Yeah.
Okay. Just in terms of the benefits then, I don't propose to... well, actually, can we just talk about the Lingfield House case? I know friends got some questions about the Section 106. Why did you think, having seen that, Mr. Pycroft alerting the team to it on Friday, why did you think that was a relevant decision for the inspector?
I felt it was relevant for a number of reasons. Firstly, it's the only VSC case that deals with an integrated retirement community that I've seen subsequent to the publication of the end 2024 NPPF, which introduced paragraphs 155 and 156 and the Golden Rules assessment. So sorry, I should probably explain. The development at Lingfield is an integrated retirement community and a GP surgery with a small area of public open space. The site is in the green belt. It's located on the edge of the village of Lingfield, adjacent to open countryside, the outcome of the appeal was assessed on the basis of a very special circumstances case. So the composition of the development has similarities to the composition of ours. The setting of the site in relation to the settlement edge and the countryside is similar to ours, and the manner in which the inspector assessed the proposal and in the context of the very special circumstances post the arrival, if you like, of paragraphs 155, 156, I think is useful and is not. It's not a scenario that's represented in any of the other material that we submitted in advance of the inquiry.
Yeah. For the affordable, they're making an off-site contribution. Is that right?
Yes, £350,000.
Yeah. I think in our case, Mr. Garside has identified the cost of the affordable housing on the site at £5 million. Is that right?
To answer that affirmatively, I would actually have to go and check.
Okay, right.
I don't disagree with that.
It's in his report, but thank you for checking. Without getting into the numbers, 350,000 as a contribution, or providing 23 units discounted in the case of 11 of them by 70%. Is the offer here, how would you characterise the offer here compared with there?
I would say it's vastly in excess of the offer there.
The GP surgery is to be built by the appellant in that case. That is different from the situation here, is that right?
It is.
Yeah, we don't know what negotiations they had in relation to that, but you draw that to the inspector's attention. The public open space, was it similar in scale or not?
No, to the extent that I was able to kind of sort of quantify it based on the documents that I was able to review, I calculated it somewhere between 0.5 and 0.6 hectares. It's a sort of a community orchard, and clearly our public open space is 8.6 hectares, so
Yeah.
15 times the size.
I think everybody knows Tandridge hasn't got a plan. I think the 5-year land supply and the decision is 1.92 years, so worse than this authority, is that right?
Yes.
Yeah. Okay, good. Other benefits then, I don't need to ask you about the affordable. I suppose with the GP surgery, the council are coming at this from the point of view, look, we've been here before, people have promised a GP surgery, and it hasn't happened. So just based on empirical evidence, they seek to reduce the wait. How much effort has gone into trying to speak to the relevant parties about the provision of a GP surgery here?
Significant effort. It was mentioned, and I apologise if I was if my language was excessive. But it was mentioned last week that I'd expressed incredulity that the local authority had sought to downgrade this, and in the context of sort of particularly this kind of concern about the lack of delivery, and in particular, obviously, Ms. Fitzpatrick in her evidence suggested that it was odd or in some way kind of sort of inappropriate that the ICB had sort of revised its position from an initial position of objection to a position of ultimately quite close to support or indeed support for our proposal for the GP surgery during the course of the application. But I think I was a little surprised by that, simply because almost like the opening paragraph of that second response from the ICB makes very clear that its position has changed because of the direct engagement that it had with the appellant and a local GP practice, and to some extent, obviously, the planning officer who'd also been present at some of that engagement. So yes, there was engagement. the ICB, which is the commissioning authority for bringing forward the funding that would be necessary to deliver improvements to the healthcare estate, sees our GP, the serviced land offer, which Mr. Garside valued at somewhere between £1 and £1.5 million, as being a very significant opportunity to deliver a GP surgery that has been an aspiration for some time. All of the engagement that I'd had with the ICB and the GP practice led me to believe that with the provision of that land in the manner that was proposed, that the onward delivery was given greater assurance. So.
Yeah. Look, there's two sides to every story. The council have obviously had some bad experiences in the past, and that's a legitimate experience. The same with the Sang. But do you see any reason why this GP surgery would not proceed, given the value of the land that is being offered for nothing, basically, Peppercorn, and the apparent need for the further facilities?
No, every indication we have is that the local GP practice, albeit that the NHS processes don't allow them to assume that they will be the party that would take it forward, but the engagement we've had with them is favourable, and the ICB were clearly saw this as an opportunity. Now, it's been indicated that the concern about deliverability of the GP surgery to some extent falls back to what was previously referred to as the Orchard Cottage site.
Yeah.
And whilst clearly I was not involved with that, and some of the considerations that may have informed the non-delivery of a GP surgery on that site in the fullness of time are outside of our eye line. But the engagement that we had with the ICB in relation to our proposal during those discussions was that there were certain facets of that permission which kind of precluded them from being able to deliver that. And we sought to ameliorate those particular circumstances in the way in which we actually proceeded with ours. So the planning officer, for example, would. I engaged with the planning officer, and we agreed, in accordance with the request from the ICB, that an extended period be included in condition number 1 for the submission of reserved matters for that component of the development discreetly. That's because the ICB had indicated, as they did in the final email that they submitted, which is in evidence, prior to the planning committee, that they anticipate a period of 8 to 10 years to have gone through their process before they would actually have a completed facility in operation. Yeah. So the reserved matters period was pushed out to accommodate that, which wasn't the case at Orchard Cottage, and I understood from my engagement with the ICB that was one of the component elements that would help the delivery here. But also, which was absent from the permission at Orchard Cottage that fell away, is the really robust commitments that we've embedded into our Section 106, that land will be reserved solely for that purpose for a period of at least 10 years. At any point in that 10 years, if the NHS gets to a position where it wishes to take the land for that purpose, then the Section 106 would deliver that for £1.
Yes. I mean, one might say some of the failings here about the Sang and the GP surgery lie with the local authority and their drafting or their approach to the Section 106. These are things they did not require. To be fair to them, perhaps some of these things are just lived experience and they become aware of the problems when the lawyers have not anticipated in the drafting covering all eventualities. But here, what period of time is given for this to be taken up, please?
10 years.
10 years. Do you think that's a reasonable period of time in the circumstances, and bearing in mind what you've said, that the NHS has its processes?
Yes, and in answering yes, that's reflective of the information that was provided to us by the ICB with regard to its own understanding of its processes and timescales, which it sought to communicate to the local authority in the email, which is in evidence at... Sorry. One of the appendices of the committee report. It was a CD3, wasn't it? So it's CD 3.1.8.
Thank you. As I say, I'm not going to ask you about the weighting and the harm overall, but because the inspector has your evidence on that. But can I just ask you about the tilted balance? We've explored that. The council say it doesn't apply. The appellant's cases, very special circumstances are made out, and so we explored in cross-examination. If you pass the very special circumstance case, then you don't have a strong reason for refusing, according to policy of the NPPF, and of course then you can apply the tilted balance. Now, all of this might seem slightly academic, because you've already passed very special circumstances, if you have. Why was it that you referred to the tilted balance? Is there evidence of that being done elsewhere?
There is, and that's obviously been established over time, because one of the two circumstances which I would say that notably has happened was the Lingfield decision that was issued on Friday, where the planning inspector in that case, having found that very special circumstances did apply, did then go on to say, and thus, paragraph 11D and the tilted balance is triggered, because by passing the very special circumstances test, you're essentially the presence of the green belt in footnote 7 is removed, because it's no longer, in accordance with paragraph 11D, a strong reason to withhold permission.
Yeah.
So in that case, sorry.
Other appeal decisions was this
Yes. So the in evidence is appeal decision relating to Grove End Bagshot, which is not far from our site. That was the first Golden Rules case in Surrey Heath, and that was allowed earlier in the year. That's at.
9.39. Thank you very much.
Thank you very much. And in that case, again, it was found to be compliant with the Golden Rules, having regard to because of the affordable housing contribution. In that case, it was an open market housing development. But again, stepping outside, it was a site within the green belt, but having established that there was compliance with the Golden Rules under paragraph 156, the inspector then went on to say or to conclude that the tilted balance was therefore engaged.
Good. Okay. Those are all the questions I had. Was there any? I'm conscious of the time. Was there anything else you wanted to add?
No.
Okay. Thank you. Thank you very much.
Thank you, Mr. Young. Thank you, Mr. Anderson. I think it's probably appropriate to take a break at this stage, so we'll break until 11 o'clock. Thank you. Adjourned until 11. Morning again. It's 11 o'clock and the inquiry is resumed. We've heard from evidence in chief from Mr. Henderson, and now the opportunity for the council to cross-examine him on that evidence. So, Mr. Atkinson, over to you.
Thank you, sir. Good afternoon. Morning, Mr. Anderson.
Good morning.
I'd like to start with the this tilted balance point. You say in a number of places that the tilted balance applies in this case.
I do.
Now, I think we're in agreement, but I just want to make sure that that's the case. So we're agreed here, in this case, that the proposals are inappropriate development in the Greenbelt.
Correct.
And we're agreed also that in order to grant permission, the inspector will have to find that very special circumstances exist, applying the test at 153 of the framework.
That's what we've invited the inspector to do.
Yeah. So in terms of NPPF paragraph 11, we are in, obviously, the second part of that paragraph, decision-making.
Yes.
We're agreed that there are either no relevant development plan policies or the policies most important for determining the application are out of date.
Correct.
So we're in 11D. So that means under 11D, the decision maker is to grant permission unless 11D1, the application of any footnote 7 policies provide a strong reason for refusal.
Yes.
And we're agreed that Greenbelt policies in the framework are a footnote 7 policy.
Yes.
So application of the Greenbelt policies in this case is essentially applying the test at 153 to determine whether very special circumstances exist.
Yes. But just in case it's helpful just to follow that my position with regard to 11D is that in the event that the inspector finds that very special circumstances exist under paragraph 153, then it follows that the Greenbelt no longer provides a strong reason for refusing the development, and therefore 11D is engaged, tilted balance engaged. So,
Okay, well,
albeit
we'll get
slightly
there. I mean,
academic.
you're heading in the same direction.
Okay.
It is right that in reaching that determination under 153, that exercise will determine whether or not the inspector grants permission,
The exercise of
determining whether very special circumstances
absolutely.
exist. Yeah. And if the answer is yes, by which I mean application of the Greenbelt policies do provide a strong reason for refusal, permission is refused.
In the event that very special circumstances were not established, then I would say that footnote 7 kicks in the Greenbelt as being one of the reasons, would provide a strong reason for refusing the development.
Yes. So permission is refused and the appeal is dismissed.
Yes.
If the answer is no, by which I mean the application of the Greenbelt policies do not provide a strong reason for refusal, then the inspector moves to 11D2.
Actually, I think 153, once that test is met, that next step isn't required. I think you can then grant planning permission 153 and you don't need to come back to this. But those two in those two cases that I raised in my evidence in chief, that is what you're suggesting is what the inspectors then did.
Okay, but let's just get this right. So I think you're agreeing that if the answer is that the application of the Greenbelt policies do provide a strong reason for refusal, the inspector's decision is, the conclusion is permission is refused and the appeal is dismissed and we go no further.
Yes.
Okay. It's in the alternative. if he finds that the application of the Greenbelt policies do not provide a strong reason for refusal, it's then that the inspector applies the test at 11D2 and determines the application in accordance with that paragraph. That's correct, isn't it?
Yes.
I said I thought we were in agreement.
Yes.
And it is 11D2 which is known as the tilted balance, isn't it?
No. 11D is the tilted balance, and and parts 1 and 2 are the component informatives that inform that.
Okay, well, I thought that was your understanding. I don't think that's correct. I'll say something on it in closing. But for the purposes of this exchange, what the inspector can't do is, if he finds under 11D1 that the Greenbelt policies do provide a strong reason for refusal, what he can't do is then apply also 11D2. Do you agree with that?
I agree that, yes, that it, is,
All right.
it isn't an alternative way through.
Yeah, in those circumstances.
Yes.
Yeah, all right. Thank you. All right, so still on Greenbelt. We're agreed that this site is grey belt,
We are.
which means it comes within the definition of grey belt in the framework, which means it does not strongly contribute to purposes A, B, or D,
Correct.
and no footnote 7 policies, apart from Greenbelt, provide a strong reason for refusal. Now, in your proof, you characterise grey belt. This is 389. And you characterise grey belt there as green belt, which may be more suitable for development in certain circumstances,
Yes.
those circumstances being set out at 155 and 156.
Yes.
Yeah. And if all of those circumstances at 155 and 156 are met, the development is not inappropriate.
Correct.
Now, in this case, some, but not all of those circumstances are met, and the one that isn't is affordable housing.
That's right.
So we can say of this application that the development does utilise grey belt, but it doesn't meet the golden rules.
Yes.
Now, if we turn to 155, 156 quickly in the framework. Do you have it?
I do.
Yeah. Yeah, with me. All right. Now, there's no mention in either of those paragraphs there of openness. Is there?
In 155 or 156. No, because I think we've probably, by the time we've got here, we've already established that we're talking about grey belt land, so to some extent this is already,
And
moved on.
155A, as you say, refers to grey belt land, and we've established and we're agreed that the test for that requires consideration of purposes, A, B, or D,
Yes,
as well as not fundamentally undermining the purposes taken together of the remaining green belt.
yes,
And we know that the purposes themselves are set out at 143 of the framework, A to E. Yeah?
yes,
And separately, in the paragraph above, 142 addresses openness, which describes the essential characteristics of Greenbelt as being their openness and permanence.
yes.
Yeah. So it can't be said then, can it, as you do, that grey belt land is necessarily more able to accommodate change in spatial and visual terms than land in the wider green belt. It's your 4.7.
Well, clearly I have said that and I stand by it, so I disagree with you on that.
I mean, the broad point is grey belt is concerned with impact on purposes rather than impact on openness, it seems to me. You accept that?
No, because I would consider that each of the purposes are contributors to, and openness is a kind of intrinsic to each of those purposes. The two are intrinsically linked, purposes and openness.
Yeah, I mean, I understand. But they are dealt with separately, aren't they? I mean, the 142 talks about the essential characteristic of being openness, and then 143 sets out the 5 purposes.
Yes, but my point is, sorry, if I'm being unclear, I apologise, that the purpose is to keep the land permanently open. That's the aim, and the land is permanently open in order to check the unrestricted sprawl, prevent neighbouring towns merging, safeguarding the countryside. So it's the intrinsic openness that paragraph 142 seeks to kind of preserve, which then has the effect of realising or not the purposes.
If I understood correctly, you're saying the fundamental aim of keeping land permanently open, you say, permeates into the 5 purposes.
Into the purposes, yes.
All right, well, I suggest that they're separate, separate points, but I understand what you're saying. A slightly different point. We know that being grey belt means that the land does not strongly contribute to purposes A, B, or D, and we're agreed that that's the position here.
We are.
But that's not quite the same, is it, as not harming those purposes?
No, you're right. It's contributing significantly is not no harm.
And there could be development which causes some harm to these purposes, notwithstanding that the land does not strongly contribute to any of them.
There could, albeit my understanding from the local authorities case is that that's not what's alleged here.
So we're concerned with weight, ultimately, in this case, not harming the purposes A, B, and D can't be considered to be a benefit, can it? Which attracts weight.
No. I think I was clear in my answer to Mr. Young in evidence in chief that the relevance of the grey belt is very much on the harm side. So it's not. I'm not saying developing grey belt land is a benefit of itself.
Okay. All right. Countryside. I don't wish to repeat the points as put to Mr. Hammond, but can I ask you this? Do you yourself find that the appeal site is not countryside, or are you simply adopting, as often planners do at the end, the expert evidence of the landscape consultant here, Mr. Hammond?
My evidence is my own, albeit clearly my evidence is informed by what I have seen and read, and to some extent the expertise and participation of others. It's important, and I think, as Mr. Hammond did, to differentiate between what the land is and what the character of the site is, because I think that's what he was seeking to differentiate in response to questions. So, if as a planner, in planning policy terms, if the purpose of a settlement boundary in a, albeit out-of-date local plan, is to differentiate between town and country or urban and rural, then I think it would be fair to say that one could say that the designation, if you like, albeit it's not explicit, of the land in question is countryside. Mm-hmm. However, I think when you asked Mr. Hammond that question, it was very much in the context of character.
Absolutely, yeah.
And my view is to some extent similar to his, which is having been onto the site, I've walked all of the perimeters of the site, both internally and externally, and centrally within the site as well. My sense on the site was very much that it's very contained. There's no visual connection whatsoever with countryside beyond. You're very aware of in the presence of commercial, residential, medium density residential, a settlement edge, a busy A road, on all sides. So to some extent, to me, it's not. It doesn't feel like you're in the countryside. It feels like you're on a field in a well, as I've said in my evidence, a peri-urban environment.
So I think the answer then to my question is yes, you do yourself find it to be countryside in both policy and character terms.
No, I don't find it to be countryside in character terms.
Oh, you don't?
No.
Oh, sorry, I misunderstood. So you take a different view to Mr. Hammond. Sorry, no, wait a minute. You're saying it's not countryside?
Yes, I believe Mr. Hammond in evidence said that in character
view, yeah.
terms he felt it didn't have the character of countryside, and I was aware that he'd said that. It kind of I mused upon it when forming my own view, and I share that view, particularly having been onto the site and with having read that evidence and then gone to the site. Yes, it makes sense to me. It doesn't. I don't feel like I'm in the countryside as I understand it.
You're agreeing with Mr. Hammond then
Yes.
on the character. All right. So just same point really. Let's put to Mr. Hammond. If I've understood you correctly, you're saying, well, once you're on the site, it's very well contained visually. There's no link to other countryside visually. You can't see. In that sense, it feels separate from the other countryside. Is that correct?
Yes.
Understanding. But at the same time, you're saying the urbanity, if you like, somehow permeates because you're aware of the presence of the road and the nearby housing. Is that a fair summary of your
It is,
position.
but I would say that my assessment of character, of course, is from both within and external to the site, as was Mr. Hammond's, and I think as was Ms. Fitzpatrick's. The appreciation of that character is experienced, for example, from Snow's Ride. In the public viewpoints, I think Ms. Fitzpatrick was particularly concerned about the gaps for the means of access to the site and the exposure of the development that would be visible from there. So yeah, my assessment of that is from the points at which it would be visible as well as from within the site. But yes, you do have a sense. I found that there was a sense of urbanity that permeates the experience both on and off and the perimeter of the site.
Is that a word, by the way, I've just made up, urbanity?
I don't know, but I understand
You know what you mean.
I understand it.
And obviously this is, your judgment is formed, obviously, notwithstanding what the 2022 Greenbelt Review says about the parcel possessing the characteristics of the open countryside. You're obviously aware of all of that.
Yes.
And also what that review talks about as the overstatement of the urbanising influences. You're aware of that? Yeah.
Yes. But
All right, so in respect of purpose C, would it be fair to say that you accept there is encroachment of something,
yes.
but you contest that it is countryside that is being encroached upon?
Well, no, because again, when we're talking in terms of purpose C, and we're talking about openness in the context of green belt, then I think at that point you're back into the what is it rather than what is the character of it. So I accept that it's beyond the green belt boundary. It's not settlement for the purposes of planning policy, and therefore we are affecting countryside encroachment.
Oh, so you I see, you do, yeah, you accept there is countryside encroachment, but that's, if I've understood correctly, you're saying that's purely in a policy sense, if you like.
Yes.
What you also say, however, in character terms, you challenge the characterisation of the appeal site as countryside.
Yes. I think in the case as presented, we've kind of separated out the assessment of impacts on the green belt, which is where this language about purpose C, encroachment was there, and in that context, I'm less concerned with character and more almost just the presence of mass.
Yeah.
In spatial terms on land that is intrinsically within the green belt and for planning purposes the countryside. Whereas when assessing the impact of the development on character and appearance, as alleged in the reason for refusal, at that point I then consider what is the baseline in character terms. So that I hope that helps to explain me saying it's both countryside but doesn't have the character of countryside.
Yeah. Now, in your proof at 414, you deal with the degree of activity, which you say would be relatively low. So, by relatively, you mean relative to the current?
No, relative to the extent of activity that's already occurring in the area.
Well, that's what I mean, yeah. Relative to the current position of activity.
Oh, sorry, yes, but not necessarily specifically on the site. So, yes.
All right. So, the activity currently, presumably you're referring there to the main road, the A30, going across the north of the site, very busy,
Yes.
and the established residential uses which surround it on certainly 3 of the 4 sides.
Yes.
So after the proposal, if it were granted, that level of activity would be unchanged, presumably.
In a very broad sense, yes. So my transport assessment tells me that I'm contributing in a very small way to an increase in traffic generation, for example, on the A30. So it's not no change, but I don't think it would be a perceptible change on the outside
Yeah.
the perimeters of the site.
That's fair. And then in addition, were the permission granted, we would have activity from 187 units of accommodation. Is that correct?
Yes.
Potentially a GP surgery
Yes.
with staff and patients. Plus the SANG, which potentially is attracting users from nearby households.
Yes. I would hope so.
Surely that's quite a lot more activity, isn't it, than the current situation?
On the site, I would agree with you. It is more proportionate to the quantity of activity that would be occurring on the site right now. I would agree with you. It would be a lot more on the site, but I also consider it's relatively low. And by relatively low, I have an understanding of my client's product and the sort of the relatively quiet nature of that intrinsically in operation.
So what, in this sense, what do you mean by relative?
I probably mean relative to the degree of urban activity that is occurring beyond the site boundaries. So both within the adjacent residential area and in the commercial developments adjacent to the site, the A30 and the wider area. I think comparative to those activities, the level of traffic, the level of activity we would generate would be lower than that.
I mean, where it's leading to is surely Ms. Fitzpatrick is correct to consider that the weight to the harm to purpose C should be substantial, given all of these factors.
No, I mean I looked at purpose C holistically, and I looked at the effect of our proposed development on the green belt in a visual and spatial sense holistically. So it considers all of the purposes, albeit the allegation from the local authority is that we are in breach of purpose C.
Yeah, sorry, just to stop you there. I mean, the assessment of visual and spatial, that's an assessment of openness, isn't it?
Yes.
Rather than purpose C, which is slightly different, although related.
Well, we've already discussed, haven't we, that I consider that openness is influential on all of the purposes.
Sorry, I interrupted you. What were you saying?
So my understanding was that you'd asked me, Ms. Fitzpatrick has
Substantial weight.
has attributed substantial weight to the harm, to the openness.
Well, to purpose C.
But having regard to purpose, the alleged breach of purpose C, yes, yes, I understand that that's the manner in which she has reached that view. I don't agree with it. But if it's helpful to explain the kind of like the difference of position on that, my judgment on the spatial and visual effects of the development on the green belt, which I've attributed limited weight to, does take account of the fact that we are only talking about one of 5 purposes. So, and on land, so the grey belt, which takes out 3 of the 5 purposes, and the absence of a substantive objection on purpose E, has depleted that weight. So I haven't attributed my weight based solely on the allegation of the.
So, yeah, I mean, this goes back to the point we were discussing earlier, the extent to which openness is separate or, as you say, permeates all of the purposes.
Yes.
And I think what you're saying is when you make your visual and spatial assessment of the impact on openness,
Yes.
you have in mind the limited effect on the other purposes than C. Is that fair? Is that what you're doing?
Yes. So if I understand you correctly, Ms. Fitzpatrick's approach would be to say we're in breach, we're affecting purpose C, and that should be afforded substantial weight. We're not affecting A, B, D, and E, and therefore those should be afforded no weight. And so there's 5 components, of which one should be afforded substantial weight. The approach that I have taken, to be fair, is to say there are 5 purposes, and we are only affecting one of the 5, on my evidence to a very modest degree. And in those circumstances, I've attributed limited weight to the spatial and visual impact on the greenbelt holistically.
So yeah, what you've done is that the overall weight is reduced, you say, because it's, if you like, has to be considered across all the purposes, whereas Ms. Fitzpatrick is saying, no, just looking at C,
Yes.
that attracts significant weight.
Yes. Yes.
All right. Affordable housing. Now, if we start with policy CP5, and you say in your proof, and you did in chief, except in your proof at 3.24, you describe CP5 as one of the most important policies for the appeal.
Yeah.
Yeah. So CP5, it indicates an even split, doesn't it, between social rented and intermediate housing. That first paragraph.
Yes. So CP5 is concerned with an overarching target of affordable housing across the borough, which aspirationally will be split evenly between social rented and immediate forms of affordable housing.
And those 2 forms of affordable housing are generally available to people who can't get a mortgage. Certainly social rented doesn't require a mortgage. Intermediate might require some sort of specialist shared ownership mortgage.
I would understand our product to be an intermediate product, but yeah, you're correct that social rented affordable home would not require a mortgage.
And both of those forms, social rented and intermediate, would require the involvement of a registered provider.
No, a social rented product would typically require the involvement of a registered provider, but I think there are forms of intermediate housing as it was understood and defined at the time that this policy was written, that it would include what we would now understand to be discounted market sale, as one component of intermediate affordable housing. Sorry, that's
Finished, yeah. What you say about CP5 is that there is no site-specific requirement, that the broad aim, if you like,
Yes.
isn't specifically related to individual sites, is it? It's an aspiration across the whole
That's right.
plan.
That's right, and which is why in evidence in chief I'd indicated through to Mr. Young that CP6 is kind of is more the trigger policy that on a site-specific basis.
But you deal with them together, I think,
Yes.
reasonably. If, just thinking about CP5, if there isn't a site-specific requirement there, how would the split, in your view, ever be affected?
Because again, in combination with CP6, there are I'll take you to CP6. The second part of CP6 says that that the Borough Council would encourage, unless evidence of housing need or viability suggests otherwise, that the intermediate, affordable and social rented units would be provided in accordance with the SHMA or other subsequent assessments, and the 50-50 split that's in CP5 follows from the SHMA. So
So you're saying CP5 and CP6 essentially do require a site-specific 50-50 split?
They encourage it in certain circumstances, but those circumstances are where either other evidence or viability would suggest otherwise. I think my overarching view is that there's clearly an ambition to kind of secure roughly a 50-50 split between intermediate and affordable and social rented, when in terms of delivery across the borough broadly during the life of the plan. But the policy actually essentially sets the scene for a negotiation on a site-specific basis. Informed by evidence of need and viability.
Yeah. And in this case, we agreed, though, that discounted market sale is certainly not social rented,
Correct.
nor is it an intermediate form of housing.
I do think it was. I think it is an intermediate form of housing, as was defined at the time that policy was written.
Okay.
I would have understood a discounted market sale, essentially a product that's either rented or sold to eligible households at a discount of 20 or more percent, is what I would have understood intermediate housing to be at the time that policy was written.
I mean, intermediate is, as I understood it broadly at the time, considered to be shared ownership. Is that correct?
No, that's not it would include shared ownership, but I don't think it would be exclusively shared ownership. It could also be a rental product, for example, or a discounted rental product.
A discounted. So I see. So your understanding is that the direct market sale is intermediate. Is that because the point which was made earlier? It is a lease. It's a sale of a lease. Is that what you're saying? And presumably the developer keeps the freehold. Is that what you mean? Why you say it's intermediate?
Well, I'm not entirely sure of what the tenure perspective would be in this case, albeit indicatively, so a lot of these units are apartments, so that would make sense. But no, it's less to do with how the controls around it, and more to do with the discount. So the property is sold either freehold or leasehold at a prescribed discount, which would carry through. It's in the Section 106, but it would also probably carry through the deeds or the title of the property, so that the first purchaser gets the benefit of that discount against market value, and that discount against market value is repeated each time that the property is transacted. And so the affordable housing component is the discount that's secured.
And this is your equivalence point. So if I understand it, you say that, well, the 70% subsidy on the DMS is equivalent in monetary terms to social rented, broadly.
Yes, but I'm willing to go as far as to say that equivalence was an ambition, or is an ambition. I think equivalence is clearly, they're not identical. Equivalent would suggest something which is unequivocally equal.
Same, yeah.
But what we heard in evidence earlier this week was that at a 70% discount, the property is essentially being sold to the occupier at roughly the value that you would expect the property to be sold to a registered social landlord, and that the mortgage repayments on a property at the 70% discount would be comparable to the rent that a social housing tenant, a social rented tenant, would be paying for that product. So from an affordability perspective, obviously the ability to secure a mortgage aside, the actual amount of money that the persons occupying the property would be paying for that on a weekly, monthly basis would be similar in a social rented tenancy or repaying a full mortgage.
But that's the point. I mean, you say ability to get a mortgage aside. In that sense, the social rented 70% discount equivalence, it's not at all equivalent, is it? Because social rented, we've established, doesn't require a mortgage. It's fundamentally different in that sense, isn't it?
I would say it's not equivalent in terms of the process you would follow, and clearly it's not a product that's going to address the needs of someone who isn't able to secure a mortgage. But what our evidence does demonstrate, and which takes us back to the terms of policy CP6, is that it does address a very significant identified local need that would not otherwise be met.
Would it be fair to preface, and you fairly describe it as an ambition, but would it be fair to say that the equivalence which is sought is a financial equivalence?
Yes. I would just take the opportunity at this point to say the policy compliant requirement for the combined whatever 10-year affordable housing was 13.2 units. And within the development, clearly we are proposing 23. So we have an exceedance on delivery of 10 units in numerical terms, but a 70% affordable housing contribution overall, which obviously compares favourably to the 35% ambition across the borough and the 40% contribution that would generally be sought on a site from this side, a development of this size. So at the time that I was working on the planning application, and obviously prior to the determination of the application, and I think to some extent something that influenced the officer's recommendation that planning permission should be granted, was that an acknowledgement that whilst a pure 10-year terms, and the offer was slightly different at that time. It's been improved.
It has changed, hasn't it?
But in pure 10-year terms, we may not be fully in accordance with the word expectation or aims of the 10-year segregation in policy CP5 or CP6, but that the exceedance of provision overall by some margin outweighs
in your
any depletion of the contribution of the affordable housing.
Yeah, it has. The offer has improved, hasn't it, since the committee stage?
Yes.
Am I right that at that point, 23 units, which is the same number were offered, but it was a 30% discount with no income cap. Now, the discount has increased significantly to 40% and 70% for roughly half of those 23 each, and with an income cap in the Section 106.
Yeah, so not quite. Now, this is going to be I was going to say, but to be fair, I'm actually now doubting myself, but at the time that the application was submitted, the discount was 30%. I'd thought that by the time we got to committee, we were offering 40% discount across the 23. No? No, okay, 30.
Mr. Burgess has stepped out, but we'll get this checked.
Well, the point is it's improved since the determination. Yeah.
But in relation to the income cap, I think we would always have anticipated that there would have been an income cap, but because we didn't get through the planning committee stage, the detail of the section 106 was never that resolved. But I think would have anticipated that there would always have been an income cap.
All right. Back then to the golden rules, if we may. And we've already touched on this paragraph, which 389 of your proof. We're agreed that it doesn't comply with golden rules, and that's because there isn't enough affordable housing provided to fulfil those.
That's right. I think I set out there and calculated that in order to comply with the golden rules, which would be 50% of the 33 plus 15% of the 154 gets us to 39 units. So
That's
we
right.
have 23 units of affordable housing. You would need 39.
16 more.
Yeah.
Again, this paragraph 389, which I think is an interesting one, and you say, you describe the golden rules there as pulling together a group of attributes, and those are, you set them out broadly, infrastructure, public open space, and affordable housing. Yeah?
Yes.
Yeah. And if those, it's right to say that if all of those attributes are met and the golden rules are complied with, we've agreed, and it's in the framework, that that makes the development not inappropriate.
Correct.
It's a route to appropriate development,
Yes.
which is new-ish.
Yes.
But that goes beyond weight, doesn't it?
In what sense?
It's a different category. If we're talking about appropriate development in the Greenbelt, that's a different category, or different exercise to the adding up of weight to determine whether the inappropriateness is overcome.
I agree to a degree, but clearly what it is it's a kind of a defined package of measures that combine to outweigh. So the reason I referred to it in that way and have, you know, and the reason I think that that's a useful way to kind of look at it is to say actually, you know, there is a quantification of benefits there which are found intrinsically by paragraph 156 to outweigh the harm to a grey belt site in the green belt. So it's useful for just as a benchmark.
But I think that's the point I'm making. It's not a question of outweighing the harm. It makes it appropriate. I mean, it's different. It's a different route to approval, if you like, isn't it?
It is, but in writing that policy, one can imagine that you know, policymakers acknowledged that the Greenbelt was going to have to kind of take some of the pain in terms of to achieve the government's ambitions of affordable housing delivery, and then looked at how can we rationalise that in a way that's sort of, you know,
Which
as a balancing exercise.
Which are the most important benefits, which we can...
which is
I understand that.
identify the areas of...
He hadn't quite finished though. He had said, and looking at how to rationalise it, and you jumped in. So if we could have the rest of your answer about the about what it is. You were describing it as, forgive me, as a defined package of measures.
Be quiet, please.
Let him answer them,
Yeah.
but I don't think you need to coach him.
Please.
I think I've lost my thread, but
Well, that's the point of the intervention, isn't it?
no, it's not. I had indicated to you that I think that the Golden Rules is a package of benefits that one can look at the components of, and which the policymakers have kind of concluded is of sufficient combined weight, affordable housing, necessary infrastructure, open space, to then outweigh harm to a site that's been defined to be grey belt.
Yeah, but I think the point I'm making is it's not quite the same as harm, because if all of those attributes are provided, you're straight to appropriate development.
Yeah, it's a different way.
Yeah. And if in this case they're not all provided, we have to go through 153 and attributing weight to determine whether very special circumstances are met.
Correct.
And in terms of 153, which is where we are, however much weight is given by the inspector to all of the attributes we've been talking about, even if he agrees with you entirely and says he has significant, substantial weight to everything, let's say, that couldn't make inappropriate development appropriate, could it?
No. But it can make inappropriate development acceptable.
Yeah, yeah. So it'd be reasonable to say the weight to a non-Golden Rules compliant development can never be greater than for a Golden Rules compliant scheme.
I completely disagree with that. I don't see that that one of those processes has a hierarchy above the other. I simply see it. Paragraph 153, VSCs has always existed, and there are a multitude of cases in which a package of measures has been found to be acceptable. I consider the Golden Rules is just one way in which the policy is trying to help that process by saying, here is one bespoke package of measures that has, is sufficient to outweigh the harm, and therefore a decision maker can take the view that permission can be granted. I think it's, but I certainly wouldn't say that being Golden Rules compliant is better or more important than VSCs. I think you could have and I'd arguably say we do have a VSC's case where the package of benefits is greater than the Golden Rules would deliver.
I mean, it's a different route, isn't it? Is that a fair way to say it? Golden Rules, well, I say, sort of transcends weight and leads potentially straight to appropriateness.
It transcends the need for the decision maker on a planning application to consider weight. But I think behind the policy is a quantification of weight, which is useful as a benchmark, perhaps.
Right. Consider now, move to the other side of the balance, if you like, and consider the weight to the benefits. Like Mr. Young, I'm not going to put absolutely everything that is in Ms. Fitzpatrick's evidence. But first, the GP's surgery, and just so that we understand, we're essentially we're arguing about, or we have a difference of opinion about the weight to be given to this because of the council's fear, concern that it won't ever materialise, it won't be delivered. You understand that's the difference between us, isn't it?
Yes.
Now, if we go, please, to the first of the ICB responses, which is at 316. Sorry, I'm just getting there myself. 3.16. Yes, they're out of sequence.
Yeah.
Yeah, the first one is
Yeah.
first one in time.
16.1.
Yeah. Now, we can see under the heading primary care, estates infrastructure, in the second paragraph there, the ICB at that time, in the second sentence starting, we don't support provision of this land. You see that as an acceptable developer contribution.
Yes.
Yeah, when provided the land opportunities for entirely new healthcare estates, the ICB currently has no access to capital to develop new NHS facilities. New build sites cost significantly more than making amendments to existing premises. The nature of our restricted estates revenue budget often renders these projects unaffordable. And then the paragraph below talks about, additionally, where GPs have adopted new build premises, the sizes of these facilities provided under the health building note generates much higher running costs than previous infrastructure. So partners are often forced to withdraw due to being unable to afford ongoing bills and maintenance. So it's fair to say at that point, in July 2024, the ICB didn't want the, if I can put it, free land, you know what I mean? Yeah?
That was the
Yeah.
preliminary response to the proposal, yes.
And they set out the reasons. Essentially, they don't have the finance. New build costs are much more, and running costs are much more for new build as opposed to refurbishment of existing.
That's what they said.
Yeah. And then if we turn to the second response, which is (316). Sorry, I just get it myself.
Is it the CD 315? It was actually above the last one in the list.
Yeah, you're quite right. Sorry, yes, I've got that. I've done it the wrong way around. 315, yes, you're quite right. So this is the same outfit 6 months later. Now changing to some extent, saying something slightly different.
Should I just qualify? The outfit is the council's statutory consultee on health services and the body that's responsible for the delivery of primary care services.
I don't mean to diminish it by calling it outfit.
Okay.
And then in the final paragraph of the first page, we can see they're more receptive now. While the financial contribution will help to address immediate capacity demands, the inclusion of service land at Snows Ride is a significant opportunity for long-term healthcare provision. The proposed provision of service land at Peppercorn may offer a credible solution subject to patient engagement and financial considerations.
Yes.
Yeah. Is it fair to say that the financial considerations referred to there are likely to be the same financial considerations as had been explained in the earlier letter of July?
No, I don't think so. And to some extent, my response to you is informed by the fact that I was involved in those discussions. And what the representative of the ICB explained to me is that they have a very complicated procedures that they need to follow before they're empowered to make any kind of decision. So, for example, and finance, the availability of finance is one of those considerations, but also from where that finance will come. So, and you can't preempt what the outcome of that process may be. So patient engagement and financial considerations are relevant, but they're very multifaceted, and they're intrinsic to the processes that the NHS would have to follow before it was able to commit to any particular position.
Okay, so yeah, they emphasise then, I think what you're saying is the complexity of the steps which the ICB has to go through.
Yes, but
in order to secure
yes,
funding.
Absolutely that.
Yeah.
But what I would also say is clearly in the first response, some of the financial matters that were being referred to would appear to be at odds with the finding that was issued in the second one, which is that actually a new build GP facility on this site is an opportunity.
Oh, yeah.
Whereas previously they'd indicated that new build developments have intrinsically higher running costs, for example. So it was a product of discussions and an understanding, actually, that they had an operator here who had a very, very genuine interest and commitment to delivery. Whereas I think genuinely the first response was informed by the same experience that the local authority had about having had their fingers burnt by developers that was perhaps in other circumstances somewhat more Machiavellian in their motivations. But we obviously, in those discussions, were able to provide some assurances about what we could embed into contracts, Section 106, and our engagement in relation to the application of planning conditions that would negate the risks that they perhaps had in their minds at the time that they were just pushing back on the whole concept at the outset.
So in the second letter, the December one, they do describe it, don't they, as an opportunity.
They do.
No more than that. And they don't say in the second letter that the funding concerns expressed in the first letter have been overcome. I think what they're saying, your recollection is, well, they haven't been overcome, but they're going to take a long time to be resolved.
Yes, they could not be overcome at that point because of the process that they are obliged to follow would not facilitate that. The ICB was never going to be empowered to, within the time frame that we were looking at for a planning application, or indeed now the appeal, be able to, essentially commit to.
And then if we go to the final communication, this is the email at Appendix F to the committee report, which is CD 3.1.8.
Yes.
This follows, doesn't it, from what you've been telling us? The ICB are essentially saying, yes, it's a good opportunity, but we're going to need 10 years in order to go through the internal processes to secure finance, essentially. Is that a fair summary of what they're saying?
I think they're saying 8 to 10 years to have an operational facility on the site.
Mm-hmm. So having gone through all the steps they need to get the funding and to build it, it's going to take them 10 years.
Yes. And when you say get funding, it might not necessarily be to secure funding that's not currently available. It's to go through the appropriate processes to attribute funding that they have or may have access to a course of action that has been informed by a process. So.
Yeah, but again, there's nothing in this email which contradicts the concerns set out in the very first letter about the increased cost of new build and running.
I think there's an implicit contradiction to that because they're embracing the opportunity of what is proposed, which is a new build GP facility. I think there's an acknowledgement. Well, I won't overstep the mark, but what sits behind this is that a long-term ambition within the area to address a GP deficiency and no obvious alternative way of doing so. In my discussions with the ICB
So
at that time.
You infer the acceptance. You say it's implicit, that's the inference you've made.
I think it would be an odd thing to write that they see it as a significant opportunity if it were in fact the case that they were still opposed to the concept of a new build GP surgery at the time.
And it's still the phrase they use, isn't it? Opportunity in the final email, that's correct, isn't it?
A significant opportunity to address long-standing and growing primary care pressures across Surrey Heath. That they welcome the proposal and have formally withdrawn their initial objection following engagement with Retirement Villages Group over the past few months.
All right. Finally then, on SANG, and again, it's obviously understood what we're in dispute with you about is, well, the difference of opinion is the weight that ought to be attributed to the, if I can put it, the excess area of SANG. Is that's where we are, isn't it?
So the way that I've attributed is twofold. It in part relates to the excess SANG and its ability to contribute to mitigating the effects of other development in the future. But also it relates to the delivery of the whole of that as a public open space, which would be available to the existing community that doesn't currently have an open space of that size or quality.
Sorry, go on. Yeah, all right, so the guidance, it's focusing in on the SANG. The guidance, I don't think we need to go through it, but is that the standard is 8 hectares per 1,000 people, is that correct?
Correct.
And that's the guidance. I don't think we need to look at it, but CD 4.6 we went to this morning. And that, am I correct, that guidance is produced by all the boroughs and with the Agreement of Natural England, all the boroughs that are affected by this SPA, is that?
Yes.
So the guidance standard for 8 hectares per 1,000 people, which equates in this case, based on the number of potential occupiers, to 2.8 hectares.
It does, and thank
correct?
you for that. That's one of the corrections in my proof, which I sought to share through the addendum that was shared.
Yes, no problem. And what is proposed here is 8.6. Is that correct?
Correct.
Yeah, all right. So quite a lot more. And the SANG guidelines, we know, describe as must-haves a circular route of between 2.3 and 2.5 k in length.
Yes.
For a SANG of this size, and also a car park. Is that correct?
No, the car park, it would be required if the SANG was seeking to function, provide a mitigation function for development that falls beyond 400 metres walking distance from the site, from the SANG.
Right, so that was the non-provision of a car park in this case, is that correct? Am I correct, was deliberate because it was never intended that the SANG is used by anybody beyond 400 metres, is that correct?
Well, the absence of a car park would prevent it from being it contributing to mitigation for a development beyond 400 metres.
But it is described as a must-have, isn't it, for sites over 4 hectares in the guidance?
Let's have a look at
Yeah,
that.
it's CD 8.37. And it's Appendix 1.
This is 3.1.7 or
8.37. Yeah, it's the Natural England, or maybe their English nature then, guidance. So if we look on to page 5 of the document, 6, Appendix 1.
Yeah.
Site quality checklist for a SANG. Must-haves. All sites larger than 4 hectares unless intended for local use.
Yeah.
Car park.
Sorry, yeah, I thought that's what I had said. The car park, I was slightly worried that you were going to kind of expose to me that, notwithstanding Natural England having agreed to our SANG design, that the absence of a car park would negate it being functional as a SANG. But what that's actually saying, I think, is that if I think, as I'd indicated, if it's to perform a function for development beyond 400 metres, then it would require a car park.
Yeah.
So you have that open in front of you. Yeah, perfect.
And also the second point, possible to complete a circular walk of 2.3 to 2.5. In this case, a circular walk has been provided, but it's shorter than that. And Natural England have said, well, that's okay in the circumstances of this case.
Yeah, I think we're very close, but there was other design components that were then that you could actually build in to mitigate the shortness.
Yeah. So in the sense of the circular walk, although acceptable, the SANG is, it falls short in quality terms, doesn't it, with the guidance? It's too short. The circular walk is shorter than the guidance suggests is required.
No, so Natural England have signed off on the SANG as a functional SANG, and the length of the walk was mitigated by additional other design interventions that were brought about as part of the negotiation with Natural England on that.
And there's no policy requirement, is there, for SANG to provide for existing residents?
No.
Or for future residents?
No, and I would say I understand that the calculation of SANG requirements for new development, which in this case would be the 2.8 hectares, does take account of, with SANG provision, also some of the underlying demand that would utilise the SANG. Because I think it's accepted that, you know, we put 187 dwellings here with a SANG next to us. There's still going to be, notwithstanding the presence of that SANG, some minor additional incursion into the SPA, but that the provision of Arsang will also kind of remove some trips by existing households into the SPA, and it counterbalances it.
I see.
So that calculation does sit within the numbers as well.
So you're saying it's sort of built in to the calculation, certainly for people within 400 metres.
Yeah. Existing. So when I talk about the benefit in terms of future housing delivery from that excess of SANG, it's not for existing households, it's for
Yeah, but there's no policy requirement for that, is there, for saying to be expected to provide for as yet unbuilt future housing developments?
no, but those homes would require SANG or access to SANG to be permissible of themselves. So the availability of SANG will assist housing delivery in those circumstances within 400
Within
metres of the
400
site,
metres, yeah.
without a car park, or 5 kilometres with a car park.
All right, then finally this, the Lingfield case. And if we, actually it's a point really about the GP surgery.
Yep.
If we turn to the section 106, which accompanied it, which is now on the web as CD 1016.
Hold on.
If you want.
Yeah, I'm fine on here, but thank you, Mr. Henderson.
Thank you.
Thank you.
So I'm just interested in you in your proof. You set out the weightings to given by the inspector in your addendum proof. Sorry.
Correct.
You give the weightings which the inspector gave to the GP surgery, and he gave significant weight, didn't he?
Give substantial weight.
Substantial, yeah, sorry. Now, if we look at the section, to the GP surgery, yeah.
Yeah.
We look at the Schedule 5 of the Section 106, which is on page
Yep.
21. Do you have it?
Oh, 19, I've got.
Sorry, PDF 21, it might be.
Okay.
Yes, you're right, 19 in the document. We can see there that the Section 106 is quite restrictive of occupation, isn't it? It says at 1.1 not to occupy any C2 unless and until construction of the medical centre has commenced. And at 1.2 not to occupy more than 75 of, I think, 107
Yeah.
until the centre is practically completed and to turnkey standard.
Yeah.
So that's very different, isn't it, to our case. We will see this afternoon there were no such provisions in
That's
Section
right.
106, yeah.
No, that's right. We are offering, we're proposing to transfer the land holding as serviced land to the NHS upon request over a period of up to 10 years at nil cost, for £1, and that
Yeah.
land has been valued at between £1 million and £1.5 million. But we're not proposing that the appellant or the development should contribute to the actual cost of building the structure itself. In part because we've it's not proposed.
So it'd be reasonable to say that at Lingfield, we don't know, but the inspector is likely to have been satisfied that the GP surgery would come forward as intended because of this requirement in the Section 106 limiting occupation of the IRC.
I think that the commitment to build is the reason why he's afforded that substantial weight.
But it's a much stronger commitment, isn't it, here than in Lingfield than is proposed in your case?
Yes.
Yeah. All right. Thank you, Mr. Henderson. That's all.
Thank you.
Thank you, Mr. Atkinson. Just a few questions, please, Mr. Henderson. Help me here. Is there a difference between my assessment of the visual aspects of harm to openness compared to visual harm in terms of character and appearance?
Yes.
Can you help me as to what the difference is?
Yeah. So I see the green belt as the purpose of the green belt is openness, and so the physical presence of built form within an undeveloped space intrinsically is the harm to the green belt. Whereas in character terms, I'm then the man on the street assessing the quality of a place, and then sort of making a judgment about the effects of the development in that context. So the spatial impact on openness in the green belt is almost a numerical assessment, whereas the impact on character is essentially the kind of like the sense of the quality of the space that you're experiencing as the person on the street.
Thank you. Yes, you used the term peri-urban.
Yes.
Can you give me a definition of what you mean by peri-urban?
Yes. I'd see peri-urban is essentially it's a transitional zone between sort of a more developed and a less developed place, but in which the effects of the more developed place are omnipresent. So I was obviously anticipating the question and kind of thinking, well the council has used the phrase semi-rural, we've used the phrase peri-urban. How far apart are we? What do we mean by those two different things? And I was kind of thinking if I was beyond the site to the east, on the golf course to the east, where the land then stretches out into it's more exposed to open countryside, I might use the word semi-rural, notwithstanding that there are still some developmental influences in that space. But in this case, and in some of the locations that Ms Fitzpatrick was particularly concerned would be impacted by the development in character terms, Snows Ride, for example, I would feel very much that I was standing in a suburban residential street, as opposed to the countryside. And in that context, I think the prevalence of I think there's a small industrial estate to the south, immediately to the south of our site. We've got a builders merchants on Snows Ride, immediately to the west of the site, in conjunction with development that's at a sort of a suburban rather than a kind of like a rural scale. And so it's those and the A30 itself, and I think those influences are greater in their magnitude than the sort of a more scattered or dispersed built presence would be if I was to describe a site as semi-rural.
Okay, I think I'm there. Thank you. Just coming on to affordable housing. You were saying that, in your view at the time, policy CP5 was being written, DMS was considered a component of intermediate housing at the time. Is that still the case? Is DMS still considered today, in terms of how affordable housing is defined? Is DMS still considered to be an intermediate form of housing, or have things moved on?
Yeah, so for definitions, and particularly in a planning context, I looked to the annex of the NPPF, but the word intermediate has disappeared. It doesn't exist in planning policy anymore, and affordable housing is now defined in different ways, including discount market sale, which is why I said at the time. But I professionally have always understood intermediate affordable housing to be essentially housing that's made available for sale or rent at a discount of 20% or greater, whether or not that's part share. And then the mechanism for that might be shared ownership, or it might actually be, as we're proposing, a sold product with an embedded discount written into the deeds. Sorry, I don't know whether that was a particularly helpful answer, but intermediate just doesn't seem to exist as a phrase anymore.
It has changed over the years, so it's an interesting one, isn't it? No, that's good. Thank you for that. I think I'm okay with that. Or am I? You've accepted that the development is inappropriate because it fails to meet all of the golden rules.
Yep.
Once it's inappropriate, it attracts the substantial weight as set out in the PPG, in the framework. The introduction of grey belt, and indeed for that matter the golden rules, as it were, have added have obviously added additional complexity, I guess, to how one goes about considering whether or not development is inappropriate. Is it the case that there are shades of inappropriateness, or is it a case that either a development is inappropriate or it isn't inappropriate?
I would take the view that there are not shades, that it either is or isn't, and that's probably I think the green belt is quite a blunt tool, other than obviously in these additional kind of features that have crept into policy in recent times. But I think it's quite helpful to kind of see it in a binary way. That I haven't spoken about this yet this morning, but obviously I had attributed substantial weight to the definitive harm to the green belt, because that's what the NPPF says.
Because that's what the NPPF says, yeah. No, that's right. Okay, that's good. Thank you, Mr. Anderson. Anything in re-examination?
I think there are 2 points, and they can probably actually be dealt with by way of the information. Section 106, the trigger for the...
Sorry, which section 106 are we talking about? The Lingfield one?
Our
okay.
section, there were questions about that. I just asked my solicitor to explain the trigger in our case in respect to the GP land. I don't need to re-examine this, but there is a trigger, and we'll just highlight that when we get to that session.
Okay, do that.
And the definition of intermediate is what this is saying. I'm not going to re-examine him on what he recalls, but we'll just provide you with the glossary from the 2012 version of the NPPF, which would have been almost concurrent with the local plan when it refers to intermediate. But if I may, I'll just read it to you.
Yeah, do that.
Intermediate housing is homes for sale and rent, provided at a cost above social rent but below intermediate levels, subject to the criteria of the affordable housing definition above. This can include shared equity, shared ownership and equity loans, other low-cost homes for sale and intermediate rent, but not affordable rented housing. So it did include low-cost housing for sale.
Although, sorry, that came out after the local plan was adopted, didn't it?
A month, yeah.
Yeah.
But when it referred to intermediate, and for all that time since that definition, intermediate was thought, certainly for those 6 years, maybe longer, to include low-cost market housing, and that's what the witness is saying.
Okay. that's interesting. Thank you for that,
We'll just put that in as an extract.
if you will. Anything else?
No, so thank you very much.
Oh, that was the 2012 MPO. Okay. Right. Thank you. Thank you, Mr. Henderson. You're free to step down. I think it's appropriate to take lunch now. Can I ask, obviously this afternoon, the first thing we'll be doing is a roundtable session looking at the Section 106 agreement, of which I now have a final draft, and then going on to look at conditions. I have discussion about both. So I think I will be. I think I budgeted an hour and a half, and I think we'll probably be taking all of that. I have probably more questions on the conditions than I have on the Section 106 agreement, but I'd like to cover both in some detail. As well as who will be attending that particular roundtable session?
So from the council side, Mr. Stephen Bell, who has appeared behind me, will be speaking.
Okay, thank you, Mr. Bell. Will we have Ms. Fitzpatrick as well? Certainly in
Well,
terms of
everybody, yeah.
conditions.
Yeah.
Okay. And then from,
I will be attending together with Mrs. Burgess.
I don't think I took Mrs. Burgess's name before, so can I have it in full?
Miss Jane Burgess.
That's
HCR Law.
Thank you. Okay, where are we? We're at 12:30. Well, let's adjourn until 1:30, and we'll tackle those two documents at that time. We're adjourned until 1:30. Thank you. Okay. We're at 1:30 and the inquiry is resumed. Business for this afternoon is to look firstly at the Section 106 agreement and then secondly at the conditions. And then after that, I'm off to visit the site, but the rest of you are able to use your time wisely for the remainder of today. Okay, if I may then, as I understand it, we've got Mr. Bull, is that right, from the for the council?
Sorry, sir, Mr. Bell,
I do
B-E-L-L.
beg your pardon, I've already
That's okay.
got that wrong. I do beg your pardon, Bell.
Bell, B-E-L-L. First name Stephen, S-T-E-V-E-N. I'm a solicitor advocate at Burkett's LLP, B-I-R-K-E-T-T-S, LLP. And sir, to my right, as I was on leave for the last couple of weeks in the US, my colleague to my right is Karen Luxton Walsh, L-U-X-T-O-N dash W-A-L-S-H.
Sorry, I've got the Luxton bit, just tell me the other bit.
Walsh,
Walsh.
W-A-L-S-H.
Thank you.
And she's a solicitor at Burkett's. And she was dealing with the 106 in the last couple of weeks in my absence, sir. So we'll assist all we can. But you do have, what I understand and what I've agreed with Ms. Burgess, a agreed form of the 106. So hopefully, subject to any questions you have, we are there or thereabouts.
Okay.
Thank you.
Mrs. Jane Burgess, I have got that name right, haven't I? Miss, do beg your pardon. Okay, that's fine. Thank you very much. So I will be working from the copy that I received this morning. Can I just check that a copy of that has gone up into the document library? In preparation, obviously, I didn't have that, so I was working off an earlier version, the latest version that I could find in the document library, which I think is, well, I have it down as CD 8.40, which was a draft dated, well, it wasn't dated, but it was uploaded on the 1st of April. I think as we go through, if there are any differences, significant differences between that version and the latest version, can you please flag them up for me, so just that I'm aware of those. Okay.
So would it be helpful for me to summarise the 106 for you, talk you through? I'm not proposing we turn pages.
No, I think what I'd like to do is to go through it in some detail. My intention is to go through it schedule by schedule. I'll ask some general questions about the bulk of the document, but it's the schedules that I'm interested in. Okay. My interest lies in whether or not the various obligations contained in the undertaking meet the tests set out in Regulation 122 of the SIL regulations, repeated in paragraph 57 of the framework. So most of my questions are around those issues. Can I start with you, Mr. Bell? Are you happy that as far as the document is concerned, its title, the title of the land and the wording of the document are, in your view, suitable? It's an enforceable document.
So, yes, we've had numerous negotiations in the past few weeks, even up until this week, with regards to the 106s in front of you. But what appears in front of you, I would say, would be Reg 122 compliant, sir, and enforceable for you to consider as part of this appeal.
Okay, that's good. I do notice in the version that there is still some various elements highlighted in yellow. What's the purpose of that?
So if I can assist?
Yeah.
It's standard practice before we prepare engrasements to highlight clause reference numbers so that we do a final check before we produce the engrosements that the clause numbers are in fact correct. And if you highlight them, it's a faster way to do that double checking.
Okay, that makes eminent sense for a document of this length and complexity. And in actual fact, the page numbering on the contents page, I think, should also be highlighted in yellow because that needs changing
That's
as well.
absolutely correct, yes.
Yeah, okay.
So in addition, and I haven't discussed this with Ms Burgess, but it's an obvious point. Page 2 contains a list of contents. Obviously, we'll need to just twiddle with that and add in, there's now a Schedule 8 to deal with the BNG element, which we've been discussing and concluding this week with the appellant. So we will need to address that, but again, that's more administrative than anything. But for the perspective of the PINS guidance, your guidance, it is page numbered, it's got all the relevant parties, the format accords with the national guidance.
Okay,
Thank
that's
you.
fine. And then as far as, I mean, it needs to be dated and signed by a variety of parties, as I see. In terms of timing, and just being aware, particularly of, say, the county and the borough's cycles for whoever has responsibility for signing these things, have you any ideas about timescales for the submission of a copy of the completed document? Probably looking to you, Mr Atkinson, first.
Yeah,
Yes.
can I assist? Because I've discussed this with the council.
Okay.
We would be seeking a 5-week period within which to get the Section 106 executed and a certified copy sent to PINS. The reason for that length of time is, as you have outlined, there are a number of parties that will need to sign the 106, and in particular Surrey County Council has set sealing dates each week, so we will need to make sure that we hit that sealing date as part of the execution process.
Okay.
That timescale has been discussed and agreed with the council.
Okay.
Yes, sir.
That was somewhat longer than I was anticipating.
So I imagine that's possibly the case, but with the parties here, with a fair wind, we're hoping obviously to get it within that period of time.
Yeah.
The usual is 4 weeks. I think it's just a question of...
I normally
Potentially.
require shorter than 4 weeks, actually,
You
Mr.
require...
Bell, but,
okay. Yes, sir.
all right, look, it's important that it's done, and I do appreciate there's quite a large number of signees on this one. I think, according to me, that would take us to the end of May. That would take us to, well, let's say the 29th of May, roughly speaking. Certainly from my own point of view, I'd be seeking to try and meet, to issue a decision before that time. In fact, my own internal target is the 22nd of May. So my preference, I think, well, let us keep the 29th as a backstop, but I really would ask all parties involved, if at all possible, to get me that completed document well within that period.
Thank you, sir.
Is that fair enough?
I think it's a question of we will do our best to get it done as soon as possible.
Yeah.
I'm just mindful that I, and Miss Burgess no doubt, would not want to be delaying your decision any longer than if you gave us 2 weeks, for example. If
Well,
there was an
I
issue.
don't want it to be unrealistic. I think from
Correct.
what you're telling me, 2 weeks is unrealistic. So,
Correct.
Yeah.
Yes.
Okay. Well, yes, I'm conscious that you don't have any control over how long it takes the county and the borough to sign, and they have their own internal systems, I'm pretty sure. So
They do. I've never asked for 4 weeks before,
Yeah.
and I don't think it's necessary either. The signatories on our side are all in the country. They're here. We're not having to send this off to Canada, so we can sign it.
Yeah.
And I think if the county council know that it's 3 weeks, however their processes operate, they'll need to raise that and meet that timescale. So we should in no way be delaying any judgment, whichever way it is that you make. So 3 weeks from now would be before your intended date of decision.
All right, well, as I said, I appreciate there are practical difficulties. I'm going to leave it that I expect to see it at the very latest by the 29th of May. If it can be done within the 3 weeks, as Mr Young is suggesting, well, as I say, that's all well and good. That's what I'd be asking you to aim for.
Thank you.
Okay, let us then move on to the schedules. And while we're looking at the schedules, I have in mind also the statement on behalf of the council, which sets out their justification for some of these clauses. So if I may, I'll start with Schedule 1, which is occupation of the extra care units. Now, that covers quite a number of things. It first of all covers an age restriction on the extra care units, the requirement for health assessments, the requirement for a personal care package, the requirement for there being a care agency or a care agency services available on site, the provision of communal facilities, and the provision of a minibus. Now, I understand the requirement for age restrictions and the requirements for health assessments and personal care and the like, in the sense that these are extra care units and those are, as it were, precursors to that being done in terms of the actual planning use of the units as C2 rather than C3. Is my understanding right there, Mrs. Burgess? Yeah?
That is correct, yes.
Okay. Where does the minibus fit in terms of it being necessary?
So the minibus is usually provided by RV on many of their retirement villages as a means to enable residents to do planned visits, whether that is to the GP practice, hospital, or events out that are planned for the guests. And it enables local residents to feel comfortable about perhaps giving their car up slightly earlier than they would have done in moving into the accommodation.
Okay. Perhaps I'll turn to the council then, really. In terms of the justification for it, I can understand the benefit of it. That's fine. I can also understand there potentially been arguments around issues if there were concerns about accessibility to the site and that a minibus is required for mitigation. But none of those arguments have been put forward to me. So in terms of justification against the regulations, what argument does the council have for it?
If I can answer that, it's been considered as part of the choice available to residents and to reduce reliance on their private cars. So it's part of the travel plan proposals that the County Highway have assessed the proposal against.
Okay. I mean, I take it that from an operator's point of view, you have no problems with this being a requirement within the obligation.
That is correct, sir.
I mean, the truth is we'll provide it anyway because it's part of the package that they are introduced. So, if you were to find it was not SIL compliant, you get into that scenario where inspectors say, I don't find it, SIL compliant, but it's up to the operator. It'll be provided. I understand your point. They haven't raised an accessibility case against us. I think it is just really for the amenity and convenience of the residents, primarily.
But you can see that that's not necessarily a necessary requirement. It's a benefit. I can certainly see that. Okay. All right. Thank you for that.
Sorry if I might add, it's in the context of the limited public bus service available in the area.
Okay. Although the bus service down the A30 is pretty good, I think, isn't it? No? Oh, okay. I tell you what, let's not go there, because there is some evidence that's before me. Okay. Let's move on to Schedule 2, which is financial contributions, and there are a number here. Yes, let me ask you a question about the first one is health contribution, so 2 tranches, for the expansion or improvement of local GP practice surgeries. I can understand the need for that. My question to you is, how does that integrate with, or what is the requirement for it, given the fact that land for a GP surgery is also being proposed as a head of term that we'll come to? I'll look at the council for that one in terms of a justification. Is it double counting?
Sorry, just to clarify, do you mean the contribution to the doctor's surgery?
Yes. Let me explain myself. In Schedule 2, there's a requirement for a series of financial contributions. One of those is a financial contribution towards improvements of off-site GP practice surgeries, or whatever else the health authority, or ICB in this case, would wish to do. There is, in addition, obviously, an offer being put forward by the appellants to provide an area of land for a GP surgery on site. Now, those are two different requirements that are set down in the agreement. My question is there a degree of double dipping there?
No, I think they're two separate arrangements. One is specifically the provision of the land. That is one contribution. The second contribution of 92,000 or thereabouts is a separate contribution, and it was as a result of the NHS asking for contributions to cover new residents in the early years of the development. And the council has said that that is not compliant.
Does the appellant have any issues with that?
We haven't raised a concern.
No. All right. Let me come on to the second financial contribution. There's a requirement for a SAM. Help me here. I do get acronym fatigue when it comes to ecological matters. What does SAM stand for?
It relates to the SANG. It's a strategic access maintenance and management sum, which I believe is transferred to the bodies that maintain the
Just say that to me again, Mr. Henderson. Strategic access,
maintenance and management.
maintenance and management.
Or management and monitoring.
Oh,
Yes.
management and monitoring. That sounds more likely.
And it provides funding for those recreational sites that do actually sit within the heaths.
Yeah.
And measures to mitigate the effects of the recreation that does occur in those spaces.
You're familiar with
You
the
can't really work in the southeast and not have stumbled across the Thames Basin Heaths SBA at some point. So yeah, no, I'm aware of it.
Robin Purchase at the University for an appeal for the University of Reading, when this was an issue, was asked about why were you providing SANG and then making a payment as well, and he coined the phrase "pay it again, SANG."
Nice. Sir, if it helps in any point, page 23, there is a definition of the SAM contribution. And referring to your previous point about health, again, there is a definition of the health contribution which may assist you in understanding
Thank you.
those, if there's a question of interpretation. That helps.
Okay, no, that's fine. Thank you, Mr. Bell. Doesn't actually say what SAM stands for, though, unfortunately, in the glossary, but I have it down now anyway. And then the third is BNG monitoring. No problems with in principle. Obviously, Biodiversity Net Gain's a separate requirement these days, and is often dealt with just through a condition.
Yes, sir.
Where does the
It
where does
is.
the monitoring issue come in?
It's in effect the council's obligation to monitor and make sure that the BNG site is being dealt with accordingly on site. So that's a financial contribution that can only be secured in the 106, whereas obviously the condition can deal with the delivery of the BNG on site as such. This management and maintenance, not management, maintenance, the monitoring of it has to be dealt with by planning obligation as it's a financial contribution.
I thought the same, Mr. Bell.
Yes.
But I was persuaded that that wasn't the case a few months back, that actually the BNG condition can
Deal with financial
can
contributions.
contain requirements for sums of money to be paid. Don't know to what extent the
That's
person who
contrary
told me
to
that was right, but
NPPG.
that was the evidence that was given to me.
That's a very interesting interpretation, sir.
Okay. However, do I take it that from a appellant's point of view, you have no problems with that being included in this rather than a condition?
We have no problems. You
Okay.
also asked us to indicate changes from the draft you previously saw. This is one area. The amount of the BNG monitoring fee in the 106 you previously saw was £11,074.90, and you'll see in this current draft there's a slight increase to £12,198.60.
Okay, thank you.
So that's at page 6 in the definition of the 106. In case you didn't get all the figures, it's there in the definition.
Right. Okay, I'm happy with that. Let's move on to Schedule 3 then, which is self-build and custom-built homes. Requirement for provision of self-build, sorry. Yeah.
Going back to the health contribution, if you look at the definition, which is on page 13, that's where first health contribution and second health contribution are defined. But it all relates to the sum of money, the 92,000, doesn't it?
Yes.
Yeah, that was understood, was it?
Yeah, no,
By
I
everybody
understood
else.
that. Yeah.
Okay. Sorry, I thought there was a distinction being made at that point between the 92,000 and the GP's surgery.
Well, I was just wanting to know whether or not they were both required. In
Yes.
the sense they're both providing health facilities which would accommodate demand coming from the site, particularly obviously the elderly elements of it. My question was really, well, what was the justification for both?
Understood.
Yes, Schedule 3, self-build and custom build, so provision of self-build plots, requirements around the marketing of those plots, and then a clause for disposal if there is no interest within a mandated period. I understand, I think, all of those. Does that, from the council's point of view, does that meet your requirements in terms of these being genuine self-built plots?
Yes, sir.
I have one query sitting here. What was the period whereby the plots could be disposed of if there was no interest? Was there a certain time scale? What was that
So
time
it's
scale?
an initial marketing period of 12 months.
12 months.
And if the council was not satisfied that the marketing had been carried out properly, they could seek a further marketing period of 6 months, making it 18 months in total.
Thank you.
And then, so whilst we're looking at that particular schedule, we agreed one change overnight with the council. If we can take you to para 1.10 of Schedule 3 that you are looking at. And right at the end of that paragraph, we have agreed with the council that the words "as open market dwellings" should be deleted from the end of that paragraph, as that is the only point in the document where that definition is used. The definition itself is also being taken out of the definitions at the front end of the document.
Okay. Does it still make sense if you delete that, though?
We believe it does.
Okay.
And your definition of open market
yes.
dwellings is on page 19.
Okay. Okay, I have no problem. If you're happy.
So we've
That's
usefully
lovely.
got a definition of dwellings in there. The definition of open market dwellings in the current draft before you seem to include affordable housing. So that was the point I raised with Ms Burgess about either we delete that or reference to it in the self-build schedule. And I don't think it needs it in the self-build schedule. And as it's the only reference to open market dwellings, it effectively says open market free from the restrictions in this Schedule 3. I don't think it needs to say as open market dwellings.
Okay.
So I think it's
Yeah, okay.
an extra we don't need, and the definition that, if you look back, could then be confused with dwellings. So I think it makes sense if we just remove it.
Okay.
Thank you.
Yeah. Okay. I think then if we move on to Schedule 4, which is the GP surgery, or land for a GP surgery. So that required an area of land of, I think it was around 0.5 hectare. Hang on, I can't find it now.
So that's correct. It's on page 17.
It's in the definition, is
It's
it?
in the definition of new GP surgery land, and it's approximately 0.5 acres.
Acres. Okay. Oh, yes, here we go. Yes, acres, yeah. Okay. Then the requirement to be retained for a period of at least 10 years. And then I see that there's also a requirement there for submission of reserved matters within 7 years. Can you just explain the reason for that?
Yes, sir. So this links back to a discussion we had earlier today with regard to the requirements of the NHS to the time frame that it would require to actually bring forward its processes to establish the actual form of development that it would require.
Okay.
And so that was very specifically one of the things that came about from in discussion with the planning officers at the time, was that they needed that extra time to establish what form of development that would actually take. So the 7 years would enable it not to fall away. Or would
Okay.
prevent it from
What would
falling away.
happen? What would happen if they didn't submit a reserved matters application within a period of 7 years? What would the effect of the clause be? I mean, would it negate the 10 years that you've been offering? Is I'm thinking to myself.
No. There would have to be an alternative consenting mechanism for planning, but the Section 106 would inure for the 10 years.
Is that your understanding as well, Mr. Bell?
Yes, that was my understanding. I thought the 7 years reserved to the, was connected to the reserved matters approval, but of course it doesn't prevent them from seeking a separate planning permission for the
No, it
construction
wouldn't
of
prevent
that.
that. No.
Hence why the retention of it being 10 years made sense in my mind, because either you put in an RM at that point or up to that point, or you could easily seek your own planning permission for such a building. And that, therefore, the key, from my perspective, I think, was the retention of it for 10 years. If that helps you, sir.
What was the purpose of putting the 7 years in? I'm struggling to see that.
So when we look at the conditions schedule, you'll see that that was specifically a negotiated point, is that the reserve matters submission has been pushed out from 3 actually to 7 years.
7, yeah. That I understand. No,
Yeah.
that I understand. It's how it aligns with the 10 years that you've been saying is a kind of a major, an important element of the change to the offer to the ICB, and whether or not the requirement then for them to, or somebody to submit a reserved matters application within a period of 7 years would seem, on the face of it, to cut down that period. Because I don't know. My question was really, well, what's the effect if they didn't meet that if after a period of 7 years nobody has put in a reserved matters? What's the consequence of that? It wasn't clear to me what the consequence of that would be from the legal agreement.
That's a good question.
So it was envisaged that after discussions with the NHS ICB that they would need that level of period of time. That's been built into the 1A6 tied to the extended RM period. If at the end of that period there has been no transfer of the land to NHS ICB or indeed a practice operating within that area, it would enable the owner to negotiate a separate deal with a private health facility to ensure that within that 10-year period there may be a GP surgery that might not be operated by the National Health Service. And that would allow that 3-year period within the safeguarding 10-year period within the schedule.
Yeah. I don't know that that answers my question. Because is the 10-year period, is the requirement that the GP surgery should be built within the 10-year period? So it should be actually operating, or at least in a position to start operating before the expiry of the 10 years. Is that your understanding? Is that how it's been drafted?
No.
No, sir. It's the land is effectively safeguarded for a 10-year period to enable either a reserved matters application to come forward, most likely within the 7-year period by NHS ICB, or failing that, a standalone detailed planning permission which could be submitted still within the 10-year period, but that might be by a private GP surgery.
So it's a bit like a school site, and that when you have a development, you allocate a site. You can't necessarily force them to build a school, but you want to safeguard that land for a period of time, so in the hope that they will come forward with their own either reserved matters or planning permission to build said surgery or school, as the case may be. So it's just securing that land to one side just to make sure it's there and available for them. Yes. Yes, so that's the point of this. The reserved matters application is the 7-year point which we've been discussing. The key for us is that it's retained in place for 10 years. So that 10-year backstop is there, irrespective of what happens in the meantime. They could clearly come forward with a separate planning application in their own right without any reference to the reserved matters. So, of course, you have your blue pencil clause within this 106. You do indeed, sir. So if you consider, then no doubt we're content with the 10-year backstop on the basis that it's definitely secured for a 10-year period. So that blue pencil is in there.
So, sir, that is clause 3.2, the blue pencil test.
However, even with you, Mr. Bell, I'm hearing that you're not too worried Sorry, Mr. Bell, you're not standing in the shoes of the ICB, but if you were, you'd be content with the clauses that, as they have been drafted here, including the one relating to the requirement for submission of reserved matters within a period of 7 years?
I think I'd be content, mindful that I had the option of submitting a reserved matters or the option of submitting my own planning application. The key is that it's secured for the 10-year period.
Yeah.
And I think that's the key for you, sir, ensuring that it's definitely secured for the 10-year period, and that the reserved matters doesn't in some way muddy the water or give us a period between years 7 and 10 where there's some form of confusion.
Yeah.
That, in my mind, is not the way that planning works. You still have the option of submitting your own application rather than being forced to proceed with the reserved matters approach.
All right.
So if you're comfortable with that, sir, mindful of the blue pencil provision within here, you may take the view of leaving the 7 years. You may take the view of just leaving it with the 10 years.
All right, I'll think on that.
Thank you,
Okay.
sir.
All right, thank you for that.
So can I just
Yeah.
draw your attention to paragraph 5 of Schedule 4, which deals with the scenario we were explaining as to what happens at the end of the 7-year offer period if the NHS ICB or the partners of a GP surgery do not take up the offer of the transfer within that time period. And if we just look at the proviso to 5.2, it makes it clear that provided the owners have supplied the council with written confirmation and evidence that neither the NHS, ICB or the partners of a GP surgery want to take the transfer, they're able to elect to offer the new GP surgery land to any other body carrying out medical and or treatment functions, and that is the private GP surgery that we were referencing.
Thank you, Mrs. Burgess. That's very helpful.
Can I also draw your attention to one point that Chris Young alluded to this morning in relation to a trigger? So if I can ask you to look at paragraph 2 of that schedule. And paragraph 2 obliges the owners to provide services up to the boundary of the new GP surgery land on the earlier of either 12 months from the RMA approval or on a 30% occupation of the extra care units.
Okay. All right. I don't think I've got an issue with that, but thank you for drawing 5.2 to my attention. Okay, Schedule 5 is the travel plan, or a requirement for a travel plan. And that requires a travel plan, a plan monitoring fee, and amongst other things, the provision of a travel plan coordinator for a period of years. I think I'm happy with that. I understand the requirements for that.
So, sir, could we just draw attention to the fact that the travel plan itself is secured by condition?
All right, okay. Schedule 6 is the affordable housing. So that, as I understand it, requires 40% discounted DMS on 12 units, 70% for 11 units. There is an income cap, and there is also a local connection criteria. Those are all covered in that. I think that covers everything that we've been discussing over the last 2 weeks. From the council's point of view, are you content that secures the affordable housing, at least as the appellants have put forward?
Yes, sir. In the current draft, that not the one that was from the 1st of April, but the most recent draft, yes.
Okay, right. Because the 1st of April, what's the difference between the two? Is it that the income cap has been included?
I believe in the 1st of April version, it didn't have numbers in it for the income
okay.
cap for a starter. Also, the wording of how it was going to be secured and the process for how it would be assessed essentially by the council. It wasn't quite what the council needed.
Okay.
But
All right.
the latest version does cover those
It
things.
covers those matters. All right, thank you. Schedule 7 is the SANG, or SANG delivery. So that involves, covers the capital works, future maintenance, the use of it in the sense that it can be used by public other than for residents on the site. There was some default clause in there relating to issues that might arise whether to be a failure to maintain, and then issues to do with the transfer of the SANG to other ownership. What has, and obviously this has been a matter that has, well, a number of matters, but this is perhaps the one that's been most recently in debate between you. So perhaps you can explain, Mrs. Burgess, I'll turn to you, explain to me what actually is now contained as far as the obligation is concerned.
Indeed, I can. On day one, you heard, I think, evidence from a statement from one of the councillors about the difficulties the council had experienced in relation to a SANG operated by Persimmon, whereby the residential houses were built and Persimmon walked away from their SANG obligations, which meant that the council had to exercise their step-in rights in relation to that SANG. We understand that the council have incurred substantial expenditure in getting that SANG up to speed and making sure that that SANG is suitable for the purpose for which it was intended. That, I think, has coloured, to be fair, the view of the council in looking at the SANG obligations for this particular scheme. And as Mr Young has outlined, there has been concern that the council may be exposed to exercising step-in rights under the Town and Country Planning Act, which might then cause them to incur expenditure which, in their view, they may be unable to recover. That's the starting point for the negotiations. You will see there is still a default provision within this particular schedule. The key, and that is in paragraph 7. That's on page 57. However, paragraph 7.1 makes it clear that it's in the council's absolute discretion as to whether or not they exercise those step-in rights. Part of the discussions over the last few weeks has been to reassure the council that they would not be exposed in any way in terms of potential liability in relation to the SANG. And discussions have been held between the owners and English Estates, who are one of the responsible bodies recognised by Natural England as being a suitable organisation to look after the SANG.
So, just tell me again who that organisation is.
English Estates.
Now, I appreciate that. Obviously, I've heard the explanations that have been given that the appellants would prefer to have the SANG ownership and the obligation to maintain it retained within the company. This, however, because of the issues that you've just explained to me, Ms. Burgess, would be the SANG would become the responsibility of a third party, in this case, English Estates. Now, it's the latter that's before me as far as the obligation is concerned. That's what you are jointly asking me to consider.
That is absolutely correct, sir,
Okay.
yes.
Right.
The other difference in the negotiation with the council is the control over the SANG contribution. That is the contribution that would be required to be paid over to English estates to ensure the maintenance of the SANG in perpetuity. Mr. Younger alluded this morning to the fact that the sum for the SANG contribution, there is a sum referenced in the viability assessment that was being produced to the council. You will note there is no sum actually specified within this Section 106 agreement in the definition of SANG contribution. That is because the commercial contract between the landowner and English Estates has not yet been concluded, but there is control mechanisms within the 106 for the amount of the SANG contribution to be agreed both with English Estates and with the council, so that the council can be satisfied that that is the correct amount of money that is needed to maintain the SANG in perpetuity. And the final control that they wish to have is that once the SANG contribution is agreed, that SANG contribution gets paid in the first instance to the council. When the commercial deal is done with English Estates, on 14 days' notice, the council will transfer that SANG contribution direct to English Estates, and that gave them a degree of comfort within the transfer process.
Okay, all right. Thank you for that. One other question, and that is, I understand that that's what's been agreed between you in general form. That's what I'd ask you to do. I'm aware, obviously, that the appellant would have preferred a different outcome. Looking at the wording of the Schedule 7, I can't see that it would be within my remit to use blue pencil clause in order to modify it so that it would move from the arrangement that you've agreed to the one that the appellant would have preferred. Is that your understanding too?
That is absolutely correct, sir.
Yeah, okay, that's what I thought.
We're not pursuing that. That was our preference.
Yeah.
And the safeguard is there because that is what Natural England wants. I have characterised it, perhaps unfairly in the inquiry, as the council insisting, the council are doing the negotiating, but Natural England are the ones who want it to go to these registered bodies. And as a consequence, that's what we're doing. You know, our point would be, well, you've got to look beyond, you know, the position that every developer cannot be trusted or might go bankrupt. And you know, if the retirement village closed, it wouldn't be there. But all that as it may, you know, we've signed up to this unequivocally.
Okay, all right, thank you for that. And then if we may, we'll come on then to Schedule 8, which wasn't in the earlier version. So this is a new schedule. Do you want to explain this one to me, Ms. Burgess?
Indeed. This is about Embracer's approach to BNG, and it has arose out of the uncertainty about the date on which the emerging local plan may be adopted. The statutory requirement for BNG is 10%. The emerging local plan requires 20%, and this is to cover the scenario that in the event it is not possible to provide 20% BNG on site, in the event that the decision letter, if that grants permission, comes after the adoption of the local plan. We want to be absolutely clear that there is a mechanism within the 106 to secure off-site BNG in accordance with a mechanism and an evidence approach to be agreed with the council. And that is set out both within Schedule 8 and the related BNG definitions. And the cascade mechanism follows a tried and tested route whereby you seek to secure off-site BNG either within the borough itself or within the same national character area, and then you go down through a cascade mechanism until you end up with statutory credits.
Yeah, okay, I think I'm familiar with some of that. This doesn't actually replace the BNG condition as such, though, does it?
It does not.
No, okay, so we still require that, okay. Good, right, thank you. That's answered all, I think that's answered all of my questions. Is there any other matters relating to the Section 106 agreement or the obligations contained in it that either side wanted to raise? I'll start with the council. Anything, Mr. Bell?
No, sir. Just to say, negotiations have been up to this week, which have usefully assisted in getting this draft to you today. So we've been working weekend, and Ms. Burgess has been getting the documents to us. So it's been very, very good to work with the appellant to get this to this position in such a period of time with a moving document. So, you know, I'm grateful for the appellant's side to get this to us in this form that we can agree this week and present to you, sir. So, thank you.
Okay, thank you, Mr. Bell. I appreciate that. Okay, anything from the appellant's side as far as the legal agreement is concerned? Good. Right, let us put that to one side then and turn to the conditions. So I am looking at the schedule that's headed version 5, in brackets final agreed. So long as we all have that version to hand, I shall go through it just one at a time, if I may. Again, my focus is on the tests in the 5 tests in the framework. In particular, it's the test of necessity. Invariably, is the one that I've been raising questions on, and in particular, because we are dealing here with an outline planning application, whether or not all of these conditions are required at the outline stage. Can I just check? I'll check with the council. Are you in agreement to any pre-commencement conditions that are included within this schedule? You are.
Yes.
Thank you. Okay, so starting with condition 1, fairly standard one relating to submission of approval of reserved matters. There included at clause B is the pushing out requirement to submission of reserved matters for the GP surgery land to 7 years. I understand that. Clause C, application of reserved matters to custom build, has been pushed out to 5 years rather than the 3 years that's normal. Can I have an explanation for that?
Sorry, it's to allow enough time for the self-built custom build units to be marketed separately.
Okay. Well, why? I mean, the expectation is obviously the condition that the permissions don't continue indefinitely, and that's why there is a time limit placed on them, and 3 years is the normal time limit. Why should it be more in relation to self-build?
I think it's recognised that in the circumstances of self-build development, where home builders will be providing unique designs in respect that they may need additional time to bring forward the development, providing that flexibility.
Okay.
Sir, if I may add to that, Mr. Rahman's absolutely correct, but the process by which they're delivered is the headline developer is going to need to sort of obtain reserve matters to the extent of the kind of like the positioning of the plots, and may actually want to kind of construct the access road and the service for the plots, because typically at the point at which the future occupiers and developers of the individual plots come forward, it tends to be at the point at which the plot is essentially already there. They will then need to individually make a reserve matters application for the particular development that they wish to construct on their individual plot, and then implement it. And the experience of Mr. Moja, who provided evidence to you earlier in the inquiry, is that 3 years is a risk to delivery of all of those components in sequence.
All right. Okay. And then my last comment here, clause D, that's effectively the time limit. It's the habit of the planning inspectorate to have two conditions, one being the reserved matters, submission of reserved matters, one being the time limit condition. Do you have any objection if I were to split those into two conditions?
We would not.
Okay. Two is what I call the plans condition. It's just establishing the plans. Obviously, it's an outline planning application with all matters reserved, so there's not really very many plans at all. I see you have the parameter plan down here, which is fine, but I don't see the location plan here. The location plan being the one that's got the red line on it. Should that also be included in the plans condition? I think it probably should, shouldn't it?
Yes, it should.
And let me just make sure, because this is one of the plans that got amended. So the reference I've got for that, it's BA 10517 2010, and then it's revision A. Is that your understanding as well?
Yes, that's correct.
Right, we then come on to two conditions, conditions 3 and 4, which seem to deal with the same thing, which was the installation of external lighting. I assume from an ecological point of view, I'm assuming that's it's probably your ecological officers who've suggested this one. What's the purpose of there being two policies rather than just one? They do seem to, unless I've misread them, they seem to cover the same thing.
I had thought the same at first, but no. Number 3 is a lighting impact assessment, and number 4 is the actual sensitive lighting plan.
Is there a difference between the two there?
Yeah, number 4 is regarding the implementation, whereas number 3 is regarding the impact of the design and layout of the lighting.
Okay. Right. Those two things can effectively be rolled into one, I think, and it would make for a simpler condition. However, my next question to you is, this is a detail matter. Isn't this a matter for the reserved matters? This is the type of thing I'd expect to see on a reserved matters application rather than an outline, because it's dealing with matters that have yet to be submitted. In this particular case, matters relating to lighting on the site.
Council would have no concern.
Okay.
Moving
That avoids then having to reschedule these. So my view is that 3 and 4 are probably unnecessary. Those are matters could quite properly be considered at the reserved matters stage. Coming on to 5. This is delivery of the SANG. Now, as we saw a little earlier, that is the provision of the SANG forms one of the obligations in the Section 106 agreement. Is there therefore any need for it as a condition? I was originally thinking maybe it was a matter that the condition required details of what the SANG would be, and then the implementation of the SANG would be the legal agreement. But clause 1 in Schedule 7 is not to commence the development until the SANG management proposal has been submitted to and approved in writing by the council. So I don't know whether that covered that matter.
As I understand it, condition 5 relates more to the design strategy, whereas the clause within the section 106 secures the SANG itself.
All right.
And the
So you
management
still feel it's
provisions of it.
necessary?
Yes.
From appellant's point of view, any particular issues on that, Mr. Henderson?
Just to
The
add,
condition is required.
yeah, that was born out of the consultation response from Natural England. You requested it as being secured by condition.
Ms Burgess has just confirmed to me that the Section 106 requires compliance with the strategy document that will have been submitted and approved
Which is what's proposed by this condition.
by
Okay.
virtue of this condition.
Okay. Okay. 6. I had trouble with this one. I understand its intent, or at least its purpose, that the development should be occupied until the vehicular access has been constructed to required standards. It makes reference to the parameter plan, but the parameter plan doesn't include any details of Belmouths. I checked that at the case management conference. So those are matters that aren't included on that plan. And it also it makes in the last sentence it's subject to possible alterations required to part of a road safety or technically agreed by the county highway authority. There doesn't seem to be very much clarity in actually what is required. And I was wondering, would it not be better to rephrase this condition along the lines of that, details of access geometry and sight lines shall be submitted for the approval, submitted and approved in writing by the local planning authority prior to, and then a threshold clause. And normally, most highway authorities would want the accesses to be put in well before the scheme is occupied. They'd probably want them to be put in before very much in the way of development takes place on the site at all, just from a highway safety point of view. Do you understand where my concerns are lying here?
Yeah.
Okay. I don't think this afternoon is the right time to actually go about redrafting that, but I think what I'd ask you to do is, can you have a look at the wording of that condition and come up with a phrasing that perhaps achieves what I think you want it to achieve, but actually it does so.
The council can take that away and agree it with the independent County Highway Authority.
Does Surrey County Council still provide some kind of model conditions concerning?
This is
it does.
their model condition.
This doesn't look to me to be one of their model conditions. So maybe you will find the answer to them in that. From a appellant's point of view, I assume putting in accesses at a reasonably early time so you can get construction vehicles on and off the site is eminently sensible.
Absolutely right,
Yeah.
and I would entirely agree with the proposed modification to that condition.
Right, and then 7, no part of the development shall be occupied unless and until a dedicated public footpath has been provided from the site connecting Snows Ride site access through to the footway on the A30 London Road. Can you explain why that is being sought? Why is it required?
I understand this is a requirement because there's no footpath. So any occupation could result in future residents accessing the A30 via a road that doesn't have a footpath. So this is to allow people to move within the site safely to the public transport options on the A30.
And that would effectively become a public footpath in the sense that public would have right of way to go along it. Is that right? Was that the intention?
If it is adopted, but it would allow residents within the new site to move within or move to the A30 without having to go onto a road that doesn't have a footpath.
So it's not public in the sense of it being open to the general public. It's for the occupants of the site.
No, it would be available to the general
It
public.
would be
So
available.
It is intended.
so the transport interventions that we are part of our package, we haven't really touched upon in the inquiry because they were a matter of agreement, but they do include the provision of a footway extending along the entirety of essentially the inside of the tree line of the western boundary of the site, parallel with Snows Ride. And that would be a footway which would be accessible to the public from the southernmost to the northernmost point of the western boundary.
Yeah, because there is another condition that requires the provision of that footpath, which we'll be coming to, I think.
Okay.
So is this a separate one to that? Can we park 7 for the time being? Because it was why this was necessary. I can understand the reason for it. In the sense that from a kind of security point of view, I wondered whether the appellants would wish to have members of the public walking through the kind of effectively the spine road, or at least within the site, or whether, people who have nothing to do with the site should be able to walk freely up Snows Ride and along the A130, but on pavements. We'll park it and we'll come back to that from my questions on some of the others. Right. 8 is no residential unit occupied unless and until an informal crossing point with drop curves and tactile painting is provided from the proposed pedestrian access point near to the junction with Snows Paddock, in accordance with the scheme to be submitted and approved in writing by the local authority. What is meant by an informal crossing point? It's not a zebra crossing, or a pelican crossing, or some kind of, what is it?
I think this is part of the general highway improvements that the appellant is putting forward.
I can understand that, but I still don't understand. There's no definition that I'm aware of as to what an informal crossing point is. Do you mean a drop curb?
I think it means a dropped curb. And markings on the highway rather than a traffic signal control.
I wonder whether this, like the condition we discussed a moment ago, actually would benefit from being the submission of a scheme for approval.
It does end up like that. In accordance with the scheme.
Yeah.
Yes.
I mean, does it mean having a refuge in the middle? That's informal, but it's, it's not a zebra crossing and so on. So, I mean, the suggestion of a scheme for a crossing point to be agreed, that leaves us with a lot more uncertainty about what it might be, but it is at least ensuring there is a crossing. I think the danger if we put in an informal crossing to be agreed is, again, there's no clarity about what that should be. I mean, being perfectly honest, for the benefit of the residents, we would want there to be a reasonable crossing point. It's in our interests to ensure that. So a scheme for an appropriate crossing point to be agreed.
Which is actually what the condition ultimately says.
Rather like condition 6, I do think this is one that could benefit from looking at a redraft, to be clear about what it is required to do. Again,
So,
it may be worth looking at the county's
yeah, so if it assists in that, I would assume you would want some form of plan from the county that at least gives an indication of what sort of informal crossing point there is, because from the council's point of view and from the appellant's point of view, you don't want to get in a position where one's thinking of something and somebody's thinking of something else and somebody submits a scheme or some plan and you're in a real mess. Is absolute.
It means just dropping a curb so somebody
Yeah.
in a wheelchair can get across the road without bumping over the curb. That's one thing. But if it's thinking behind whoever wrote this condition is that it needs to be a full crossing point, not on the road next.
Yeah.
That's far more complex.
And I think you also expose the situation to a third party who potentially seeing they might get something, but in effect, everyone's behind the scenes agreeing something else. Might,
I'm not so worried
but for here, it's necessity. Yeah. Can I just raise a point going back to condition 7, sir, just briefly, which I've been discussing here. My slight concern about this dedication of a footpath might put us up against the Symmetry case from 2020, in which the Court of Appeals said that there's a ban on planning conditions requiring the dedication of land as public highway without compensation. So it's fresh to me, but I've come across that in practice before, so I think that probably needs to just be carefully considered in light of this.
Path within the site.
Yeah.
Yeah, I mean, we're choosing, there can be objections to doing things without compensation, but an applicant can offer to do something. In so doing, we're not seeking compensation. We're trying to make sure there's a pavement on Snow's Ride, and that's in everybody's interest. There are lots of schemes with footpaths that go inside the hedge because of the now desire to preserve hedges and boundary treatments, which will be within a site. So, I don't see any difficulty with us providing that route, and indeed, I've seen it on many schemes.
Okay, let us move on. Condition 9. Condition 9 is the one I was thinking of, in that this one requires a footway to be provided on the eastern side of Snow's Ride from the junction with the A30 as far as the northernmost pedestrian access into the site, in accordance with the scheme to be submitted. So, explain this one to me, Mr. Henderson. Is this a footpath within the public highway, or what is currently verge land on the eastern side of Snow's Ride, which just allows a pedestrian access from the A30 down to the first pedestrian access into the site? Okay, so this is a Grampian form of condition, because this is going to be this footpath would lie outside land within the ownership of the appellant. Ah, okay. Okay. And how then does that link with the footpath that's referred to in condition 7?
Yeah, so the disaggregation of all of these different components of what is essentially a network is kind of confusing, isn't it? So, because condition 10, you're also going to find that you're going to be asked to narrow the access to Snow Drive as well as a separate condition. So there's a combination of factors which all align. So if you were standing on the existing pavement at the junction of Snow Drive and London Road, the aim is that the junction of Snow Drive will be narrowed, footways will be pushed into the highway, and that's condition 10, and that's going to improve connectivity. The eastern side of that footway will then wrap around into the Snow Drive on the eastern side and extend for a matter of probably, I don't know, it's about 30 metres maybe, at which point there is then going to be a point of access where you can sort of step through and into the site onto the other side of the hedge line, whereupon a footway will then carry on along the inside of the hedge line for the entire western boundary of the site, which is what's referred to in condition 7. And then, so we've gone from condition 10.9.8 so far, and then we get to the southern end of the site, whereupon that footway, which is on the inside of the hedge, cuts back through. There would be a crossing point, an informal crossing point, and then the footway then goes onto the west side of Snow Drive, where a new pavement would be constructed heading south.
Right. All right.
There's a number of components which are represented in different conditions here.
Okay.
Have a link.
Well, that's helpful because it now explains to me how some of these are supposed to work together. In some cases, it's land within the site, and quite a large number of cases, it's land outside the site. You're happy that this can be secured by condition rather than it being required as a legal agreement or Section 278?
No, we're happy that this could be agreed by condition. We've had agreement from the County Council on these points.
They're happy with that as well. Okay.
Some
Right.
works that will fall within the highway will probably require a Section 278, but that will follow from this.
Yeah. Okay. All right. Thank you.
I wonder whether then the takeaway is in relation to condition 9 and then condition 10 as well, as perhaps for we might look at each of these conditions and see if we can compose all of them in a way that makes that rational.
It almost feels since this footpath is a continuous thing, and also for that matter the informal crossing point forms part of it. It almost feels like a single condition with a series of headings, headed by the fact that the details need to be submitted to and approved by, including these, and then shall be implemented prior to occupation. That feels like a better solution. So that would cover 6, 7, 8, 9, 10. Yes. That would answer a considerable number of my queries. If I could ask you to put your heads together to draft something along those lines. Okay. Coming on to 11 is a requirement for improvements to bus infrastructure, so bus shelters, seating, lighting, passenger information, curbs, and the like. I can understand that. The only slight issue I've got here is in the second sentence of condition 11, it says the improvement and upgrading of existing bus stops located on the A30 London Road to include where possible, and then a variety of requirements. Since that where possible is rather too vague in my liking. However, since the condition requires the submission of a scheme to be approved in writing by the local planning authority, I also think it's unnecessary. My suggestion is the words "where possible" should be deleted, but otherwise the condition would seem to stack up. Would there any objection to that? Okay. Condition 12 is a requirement for a residential travel plan. However, as we've seen from the Section 106 agreement, that would seem to be a requirement of the obligation. So my question is condition 12 necessary?
Yeah, the Section 106 is the monitoring capture, but I think this still is required, isn't it? So the Section 106 doesn't require the submission of the travel plan. So we'd left this requirement we'd left to sit within the conditions, and the Section 106 is only concerned with monitoring.
So this is required. Condition 13 would appear to be a requirement for a reduction in the speed limit on Snow's Ride from 40 to 30, makes reference to a traffic regulation order and who's responsible for doing that. There seems to be a number of things wrong with this policy to me. First of all, it requires the scheme to be submitted to the local planning authority, although they have obviously no expertise in the business of speed reduction and traffic regulation orders. And the reference to the TRO being implemented at the applicant's expense, again, is getting rather too close to requiring financial matters in a condition which I'm unhappy with. What has generated this? Who has asked for this particular condition?
It's again the County Highway Authority. I think perhaps there's a missing word there. If it should say the costs associated with the traffic regulation order shall be at the applicant's expense.
Again, it's not so much the principle of there being a desire for a reduction in travel speed along a traffic limit speed on Snow's Ride. It's just whether or not a condition is the right way to go about it, or if it is, whether or not the wording of the condition actually meets the terms of the 5 tests set out in the framework.
So I'm not sure it's enforceable, because in effect it's just a scheme to be submitted. It doesn't say anyone's got to agree it.
Yeah, it's got
agree with the county.
You're right, it's got no implementation clause to it.
Anybody could submit anything and there's job done, isn't it? But it's up to the county to make the traffic regulation order. As a county highway authority, they'll have to make it, and if they don't have sufficient objections to it, then they'll make the order accordingly. But that's a separate procedure, isn't it?
So I've done lots of these with Tesco's, and what we've tended to do is provide in the Section 106 that we will fund the what's required. So both the procedure and the works themselves. And I mean, that's really what's happening here, is that, you know, we are going to introduce the 30 mile an hour limit. And yes, there is a TRO and it is a separate process. It can only be objected to under a limited number of grounds. And in my experience, on every occasion, safety wins. So there can be no question that this is going to succeed, because it's even if residents say we don't want it to be slower, unlikely, I have to say, but even if they do, the determining factor of a TRO is safety, and so as a consequence of which it will go through because it is reducing speeds, and reducing speeds is obviously safety, and indeed some of the local residents even commented on their dissatisfaction with the speed. So I don't think it's a condition at all, actually. I think it's something that should be in the obligation. And you might say, well, Mr. Young, why didn't you look at that earlier? That's on me. I probably should have looked at it earlier. It's fine to have a condition that requires a scheme to be submitted for a TRO, but why bother when you can effectively put it into an obligation?
I have to say I would normally expect it to be in the obligation.
Yeah.
I don't suppose it would be wrong to frame a Grampian condition, although even though you say it's unlikely that the TRO will be objected to, I would have to consider the issue, the consequences if there was some objections to it and the TRO didn't go ahead. What then would happen to the Grampian condition? You would effectively prevent development taking place. So there are a number of problems, I think, with this particular condition. Is this why? Well, first of all, is a reduction in speed on Snow's Ride necessary for the purposes of the development?
Yes, because we'd like people to cross the road, and
Yeah.
it's safer to cross at 30 than at 40. Yeah, and I don't think we need a condition at all, because then you don't have to deliberate about. So really, I mean, it's going to happen, and we need to fund it, and that's what's really going to be. I've only objected to this in an appeal where the council have asked for some extraordinary amount of money for doing this, but I think sensibly advised, this is not. It's going to cost more than £5,000 or £10,000, but it won't be a prohibitive amount of money, and one that we've already explored. So, no condition. We'll put it into the obligation, and the obligation principally is avoiding the mischief that you quite rightly have raised, which is we shouldn't have a condition going anywhere near the provision of money. An obligation is the means by which we give our undertaking that we will fund both the process and the physical works.
Coming on to 14, this requires
Agreed.
so as to whether or not a condition, even at a
Not
reserve
proceed to
stage,
it.
is necessary. So I think it's perhaps questionable these days.
I don't believe it covers C2 use.
Yeah, it does for C3.
No,
It does for C3, but not for
no,
C2.
not the building regulator. I'm happy for it to be at reserve matter stage. Agreed. I think given the history of the site as a farming, agricultural use, that's where that's born out of.
No.
So given the site's location in respect of the A30, this is essentially a noise insulation condition which can be subject to the reserve matter stage. Not necessarily. This was the advice given to us from our noise officer. Sorry. I think the condition is also based upon the noise assessment that was submitted by the applicant at Pelham.
Okay, fair enough.
Yeah, I mean, the regulation point is a good one, which is you're not alone. I think the planning officer side, everyone just puts the conditions on, and then it's the planning officers who end up having to deal with all this, when it might be building control, it might be environmental health, and they end up having to adjudicate and deal with all this. So, but I think, did I understand we're agreed we're going to put that off to reserve matters, such that the condition doesn't need...
That was my understanding too, yeah.
Okay, good.
21 is well, it's to do with, again, acronyms abound on this one, Construction Environmental Management Plan. Now, my first question, this is separate to the 17, which was to do with protections during construction.
Yeah.
So this is really to deal with any ecological matters that might arise on the site.
Yeah. So
Well, I asked the question, what is it for?
the previous condition is more to do, it should be read as a construction logistics plan,
Yep.
whereas this condition looks at environmental and ecological factors.
Okay. It's phrased that prior to the commencement of each phase, I'm not aware that this scheme is going to be phased, so is that a necessary part of the condition?
I think it would be quite helpful to the prospect of construction that if it were feasible to leave that in, because it may be, as you say, well, no one has seen a phasing plan, but it's not impossible that we may find that the development comes forward in phases. So if it's feasible to actually construct the condition in that way, that may help implementation.
Given we've also got the differing time limits on the various parts of the proposal, on the GP surgery, the self-build, for example.
That's true. Yes, actually, that is true. And I suppose self-build as well. All right. 22 is implementation of program archaeological work, subject to a scheme of investigation. Any problems with that, Johnson Hanson?
No.
23 requires an updated badger survey. My point is this necessary? I'm assuming that a suitable ecological survey has already been carried out on the site. I'm assuming they didn't find anything. So why is it that another survey needs to be carried out?
I think in the event a badger set is found, I think there were conditions where it could be found prior to.
Has a badger set been found on the site? When you put it that way to you?
I don't believe so.
Not at the time of the survey.
I couldn't see anything either.
Was one of those cases where the survey didn't take place over the summer or something, was it? Well, that's bats, isn't it?
Badgers are there all year.
Are they?
It's the
Forget
time that would elapse between the survey having been carried out some time ago now. and the commencement of development, which could be, well, probably is going to be over more than 2 years now at this stage. So it's a precautionary to do an update in the intervening time to ensure that there are no badgers there by the time construction starts. If badgers are found, yes. I think it's a case of we don't know.
But that's the case with any development site, isn't it? To a certain extent, I'm just wondering to what extent it's practically necessary.
I think the fact that, if badgers were found, it would significantly alter where part of the development might be carried out. So it is necessary in that regard.
24 is, well, I assume then, very similar approach, but in this case related to the fact survey. Okay, you got anything against these, Mr. Henderson? Okay.
No.
25 is a habitat management monitoring plan. Is this the BMG commission?
Yeah, so the monitoring contribution is secured by the Section 106, but the actual monitoring plan is not. So that's why we need it by condition.
This is the condition that the clause acts on. Six just requires that notice in writing should be given when the plan that monitoring plan has been implemented. I've seen that condition before, but I kind of understand why it's often now on there. Is this something you do on a regular basis?
Yeah, it's something that in the surrounding boroughs is being carried out as a condition, and it's essentially to notify the local authority that monitoring begins from this date.
And then 27 is similar. 28 is relating to security measures to minimise the risk of crime. A couple of things here. First of all, this is probably reserved matters rather than anything else. I understand that security is now being taken to building regs. It's not a matter that which is to see who schemes individual requirements.
I believe that is our understanding as well. It might have just been at the time of when the consultation was received.
29 is details of a surface water drainage scheme. I understand the need for one, and it to be a sustainable form of drainage scheme. I'm going to brackets here. Is this a reserved matter, or is it something that needs to go onto the outline? Yeah, I've always found it a slightly grey area because the drainage isn't specified as a matter. This is a detail that effectively goes part of the landscape. I don't know.
I think given that there's no development currently on the site, it's probably fundamental to demonstrate that the site can accord with the hierarchy. Yeah.
I agree, actually, at the point of submission of the reserved matters, it's going to be part of the design. It maybe isn't necessary to specify as a condition, but it would be necessary for this information to have been submitted at the time of the reserved matters application anyway. I wouldn't expect to see it as a condition on reserved matters because it's going to be too late by then. So.
No, we do not at present, so it can be covered by building regs.
Yeah, I think it is.
I think it's just to essentially demonstrate to the council that the occupier, the first occupier, is the person who has been involved in the design of the development and therefore truly meets the test of being a self and custom built dwelling. The reason born out of it is that it impacts the SANG contribution, or SAM contribution potentially. So
I had understood that it was necessary and reasonable.
So in terms of the communal facilities and the refuse vehicles accessing the site, a management plan in that respect. But this could be dealt with at the reserved matter stage. No.
You're going to be getting a copy of that to the, well, ideally within the next 3 weeks, backstop 5 weeks. It could be included there. If you are able to draft that.
So I think it's relatively easy. It's the provision of the money and also a trigger to ensure people don't occupy until this is in operation. Those particular clauses are ones which Ms Burgess will need to agree with the county council as opposed to us as the district. I don't know how feasible it is to deal with a county lawyer, hopefully, but it seems relatively straightforward to me. Pay the money, find out how much it is, not to occupy unless until. It is in effect.
And I think if the county's lawyer is told that the concern isn't the scheme, it's the fact that having a condition in that seeks money was raised as a concern in the conditions session, then it's a it's very, I would say no-brainer. It's very straightforward. It's extremely straightforward. There's a reason why we're moving it That does not take weeks of agreement. So we'll try and do that overnight. We will certainly draft it so that it can go in. And then obviously, if we don't get agreement by the county by the close of the inquiry, we'll pursue them rigorously for the following few days and say, look, you really need to just answer this, please. It's a single question. And I don't envisage it's going to take more than a week at most.
Okay, that's good. That's a way forward, I think, then. Thank you for that. Good. We've come then to the end of evidence and also matters relating to the legal agreement conditions. Any other housekeeping matters before we adjourn for today?
Just to indicate, there isn't a cost application so from us, so you will just have the closing submissions tomorrow
morning.
Yeah.
Okay, that's good. Anything from the council side? Right. Okay. I'm going to go and do a site visit.
Do you want to actually mention the other day you don't really comfort about horses, but do you want to get onto them?
Well, what I was thinking of doing was not. I don't think all of the paddocks have horses in them, do they?
They get shifted around. So
Oh, okay.
That's a normal grazing thing.
Okay. Well, my intention is I'll be walking the boundaries around the whole thing. For those paddocks that don't have horses in, I shall probably enter. To be honest, I think I'll probably gain all I need to gain from just doing that.
Okay. The northern access drive up in off the A30, you did say you drove right to the end to see the mansions.
Yes.
Just in there on the right, there's a gate. You can slip in.
Well, this is the gate to the barn?
Yes.
Yes. Okay.
Slip in through there.
Yes.
And see quite a bit from there.
Yep.
You can open the barn door and walk through, but you need to be careful that you don't let horses back up.
Okay. I have no intention of opening gates for exactly that good reason. All right. Thank you for that. Okay. Thanks for those comments. Right. In which case, I'll adjourn until 9:30 tomorrow morning. Thank you all.